Hypocrisy.
Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. How we doing tonight, chat? Squad, fam, whatever Zoomer language, hieroglyphic meme you want to apply to yourself. How are we today? I hope you're doing well. Yeah, my voice just gave out right there in the middle of a sentence. That was strange. Okay, guys, we have a special thing today. We have Tyler Robinson. Tyler Robinson, the alleged Charlie Kirk assassin, is, he requested that there be no cameras allowed at his upcoming trial. Turns out that is not the result that he got. He got the result of there will be cameras. The revolution or the trial or whatever will be televised. And we're going to have a good time watching it. So, yeah. So this should be good. We're going to watch that hearing tonight, though. What in the fake snake skin? I don't think it's snake. I think it's gator or something. Who knows? Who knows? But anyway, we're going to watch the trial, I believe, Tyler Robinson, whenever that is. I don't know when it is. Do we have a trial schedule for it? But tonight we're going to watch the hearing. I think it's only like an hour, but maybe it's 4 hours. I tried to look at it earlier, and the video is 4 hours long, but I think that was some other issue was being handled. By the way, Miss Peachy, thank you very much. I hope you're doing well. Am I playing The Wall tonight? Yeah, Pink Floyd. All in all, it's just another brick in the wall. So we've got this. And this is the main thing. There's some other stuff brewing going on. We've got Styx Hexenhammer getting arrested, which, I mean, is probably not a great thing for him. We've got some interesting stuff there. I've invited Styx on the show. He said, he would consider doing it to talk about what was going on, but I don't know how much I can ask him, and I don't know when we can set it up, all of that stuff. So, I've never had Styx on the show, and I thought we would do that. I'll answer the question now. No, the jacket is actual leather, not fake leather or patent leather or whatever. But, we probably will be taking it off at some point. It's just a little nippy in my house right now. In my office. But as I start getting angry or whatever, we'll see how that goes. Okay, so let me pull this up. Tyler Robinson hearing. But we've got the Styx Hexenhammer thing is something to talk about at some point. Is this thing really 5 hours long? Holy fuck. This might be 5 hours long, actually. But anyway, so we've got this. The Styx Hexenhammer stuff is interesting. We've also got this brewing situation in the Dabbleverse, which is this weird place I mentioned before. Many of you probably have no idea what it is, and that's for the better. And we're not going to take a full-on plunge into the Dabbleverse of the nonsensical stuff. So this is an hour and 28 minutes. I think this is the actual time. I think it's about an hour and a half. But there was another hearing that happened in the same courtroom. In the Dabbleverse is a bunch of insanity going on all the time. And we don't need to deal with that. But there's this Mersh dropped a super chat last night. I'm trying to figure out how to explain this in real time. Mersh dropped a super chat last night about Scarlett being in danger. And the Scarlett he's referring to is Scarlett Hampton. Scarlett Hampton is an adult film actress. She has opened the gates to many careers, we'll say. She's an adult film actress, and she has been romantically involved to some level with this guy named Matt Mead. And this guy seems like a real piece of shit, but I don't know him. I mean, he seems like a piece of shit. I don't know if he is. Although my piece of shit meter, like as a fellow shit piece, is going off. But a couple weeks ago, there's this video where Matt Mead was like Scarlett Hampton started live streaming out of nowhere, just from her phone in a bed. And she starts streaming and she's like, please don't hurt me again and stuff like that. And don't throw ice and water on me and stuff like that. So it was this kind of weird video. And a couple of people are like, hey, that kind of sounds like really horrible. Kind of like maybe she's being abused by this guy. And then, some retarded people came in and swept like that. It has nothing to do with the truth or the fiction of the abuse. I don't know. But some retarded people came in and like kind of swept and covered for this Matt Mead guy. And then they did another stream with everybody together where it's like, Scarlett's like, no, I'm great or whatever, which is very weird. Abusers tend to make their abuse victims admit that they're not being abused or like claim. It's part of it. It's part of the abuse. So, and I don't know if he's doing that, but it kind of seemed that way. But anyway, it kind of faded out. It faded out and I wasn't paying attention to it. And then just yesterday, Matt Mead is on a show, and I think with Keanu or something, Keanu Thompson. I know you don't know who these people are, and that's okay. Kind of shady. It's not a shirt, it's a jacket. It's a jacket. I'm wearing a shirt underneath the jacket. So yesterday, Matt Mead's on a show with Keanu, and Scarlett comes up and says straight to the live stream, like, he wouldn't let me leave. It's not my fault I couldn't make it. Like, and I'm trying to gather the information and figure out what's going on. It's kind of like she's talking to her mom or something because she maybe was supposed to go to her mom's house for the holiday but couldn't make it. I don't know. Very weird. We may be looking into like watching some of this shit and just pointing out like the abuse or criminal acts or whatever, because it might be fun. You can take a drink every time someone acts like a dirtbag. I'll be drinking Gatorades. I'll be drinking so much Gatorade that I'll be fit, I think. But anyway, so we may look into that sometime soon, maybe even tonight. I don't know. I don't know how long this hearing is going to take. I'm gonna see if we can't. It's just hours of nothing. Oh, here we go. Yeah, I think it's only like an hour and a half or so. So we'll pull that up here. This is the one we'll use. This is the first thing we're going to do, though. We're going to do, this is the most important thing, is this Tyler Robinson request to have no cameras in the courtroom. And of course, there's cameras in the courtroom while he's making this request. The reason I think it's interesting is, of course, this is a man accused of killing Charlie Kirk. So, it has just some cultural relevance. It's effectively a major political assassination. A major political assassination has occurred. And, this is a guy who allegedly did it. And I don't know that the alleged is so much. So that's interesting. He pled not guilty, even though it seems to be fairly conclusive. So I'm kind of curious what the defenses are, what the purposes of the defense are for this guy. We'll see. We'll see what he raises, what the strategy for the defense is at this point. But they are currently going to trial. Pre-trial is set for spring of next year, I think. So we've got some time before that trial will take place, and that is plenty of time for him to plead guilty, honestly. And he may end up doing that. But so we're gonna see what happens. We're gonna see what happens, Larry. We're gonna see what happens with that as we go. But in the meanwhile, we'll proceed as if a trial is occurring, and see what his defenses are. Right? Like, what is your defense if you assassinate someone in public? It's not like he was coming right for him. Charlie was sitting in a chair, but it feels uneven. Charlie was sitting in a chair and just talking, and all of a sudden he gets shot. Now, of course, we all know that Tyler Robinson didn't do it. And Charlie Kirk's special menorah medallion exploded shrapnel into his neck to stop him from speaking truth about Israel and Gaza and the history of the Jews and the ethnicity of Jesus Christ and who really killed him. Right? We know that's what was actually going on. The Jews had to stop him, so they blew up his super menorah medallion and killed him through his thing. Thank you, Candace Owens or whatever. Who suggested this? The other fascinating thing is just what it goes back to what the fuck is he going to do? What is he going to say? I want to know. I want to know what he's going to say. But it'll be a big trial, I think, if we go to trial. I don't know if they're going to go to trial at all. I have my doubts, but there are reasons you go to trial. Sometimes, depending on the case, it could be a death penalty case, and you go to trial to try and mitigate that. But it'll be a mess. It'll be a mess. Why is the volume always so low? I'm on full blast. Well, systemic racism is the main reason. No, it just has to do with, I wonder if we're on the right microphone. Let's see. Hold on, I'm just trying to make sure I have everything set all the way. Okay, I think we can... I don't know if this is going to be better or worse. Okay. Maybe if we bring that up. My hair volume is looking low. Yeah, I went to go get a haircut just to get a trim, and I was just sitting there gabbing with with my haircut girl because I like talking to her. She's funny, and we're just sitting there yakking back and forth, and all of a sudden she starts cutting, and she just cut it way down. I think I messed with some settings on my Rodecaster. Maybe this is better. Maybe this is better. I don't know. Is this one better? Who knows? Tell me if I get louder at any point here. Wear clip-on bangs. I was like, I really wish I had hair extensions right now. So yeah, we're going to do that. Yeah, Neurodivergent said it's low too. Let me see. It's all about where the sound is coming from. And where it's coming from is ultimately not great. Hola, Rita. Muchas gracias por complimenting my jacket. I don't know how to say that. Jaqueta. Oh, I don't know how to say compliment in Spanish. ¿Cómo se dice compliment? I don't know what to say. Audio's good. Audio is good. Thank you. All right, then I'm just gonna not mess with it. Where's the old Pope hat? It's right there. It's right here. Look, I'm petting it. Hello, Pope hat. Complimentor. Okay, so it's gracias por complemento or complementar, whatever. Magiqueta. No, wait. I'm mixing the French in. Sorry. We need to just stop. No habla taco or whatever. I fucking love tacos. Anyway. All right, so we're going to do this first. We're going to jump in here, and then we're going to do whatever else we want. I found out the other day that uncivil law does not care what I have to do or say. We can watch that. That's kind of funny. Very happy that Kurt does not care. I was worried that he'd be upset, but it turns out he's not upset. He's not mad at all, and he doesn't care what I'm doing. So we might need to just do that, because I think people are confused. They think that I'm vindictively mocking Kurt, and I'm happily mocking Kurt, and it has nothing to do with any sort of personal beef or animus. The only beef problem I have with Kurt was that fucking abomination of a beef Wellington, and we're not but I don't hold ill will there. What I do hold is just a lack of desire to be around someone who acts in the way he does and thinks about the world and other people the way that he does. And I think it's worthy of laughing at. I think because it's funny. It just is. I don't know. I get joy out of it. I get joy. So we'll do it. I said it 3 times. Said it 3 times in honor of Kurt. All right. One last announcement, I guess, is I'm going to be traveling sometime very soon. I don't want to give out the exact dates, but I'm going to be traveling over the next several days or whatever. And I'm not 100% sure when I'll be streaming or able to stream. I will try to do at least one stream while on vacation. I've got two trips. One of those trips is to visit my parents, my family. We're going to go visit my parents. And I tend to bring a streaming setup there. The other one is a little bit more personal. I may, depending on the circumstances of the trip, I may be able to stream, may not. We'll bring stuff to do so. And if I can, I will do something, but I don't want to promise streams. Like I don't know. I'm going somewhere I've never been. Heaven. Going somewhere I've never been, and I don't know what the available setup will be like. I don't know what the internet will be like, all that stuff. So we'll try. But if there's a little break in stuff, that's probably why. All right. So just go and unwind. Don't worry about streaming. Oh, don't worry. I'm not worried about it at all. In the past, I was worried about if I would leave my house and be like, I got to stream. I got to do this. Now it's a different perspective completely. It's I like streaming. I like talking to you guys. I like having a fun time. I'm a fun guy. I'm a ton of fun. I'm a fun guy. I like doing that. And so I want to, if I have the opportunity to do it, but I'm not going to stress if I don't. So you're unsubbing. You'll be back. They always come back.
Fancy Mike with no gain knob. What a fail. I want to see their execution of Tyler Robinson on pay-per-view.
I mean, I have a gain knob. I just try not to. You want to touch my gain knob? See, like I can do this. I can turn me way up. I just want to be careful not to pick up ambient noise. So that one was too loud. See, balancing this out, it's like I had it balanced out and then it kind of went down. Oh, I see. Here we go. Am I better? Okay, let me play that tip one more time. Steel yourselves.
Fancy Mike with no gain knob. What a fail. I want to see their execution of Tyler Robinson on pay-per-view.
All right. I turned that down a little bit more. I think that should be better. We'll test it with a different one. We'll test it. These are super tips, by the way. If you want to send it a super tip where you have an AI voice talking about Asmongold as Ronnie O'Neal, the Florida demon cleanser.
Asmon fully intends on having a sex robot. He's going to spend all of his YouTube money on multiple sex robots, and he's never going to clean them ever. Just micro peening it up.
Okay, so hopefully that's better balance. But that's super tips. Those are like super chats, but they're just the tip. You go to supertip.gg/RL. That's still loud? Yeah, that's your chat from yesterday. Okay, here we go. We got it. Yeah, I do want to pin it. Pin it. Pin this message. Yeah, damn. All right, so Neurodivergent put the pin up on Rumble, and then Jay Liebgott put the pin up on YouTube, and everybody loves a good pin up. So we have that pinned. If you want to do super tips, you can. It's a great way to participate in the show. And finally, last bit of advertising for business and money. We do push members here. We love members. Everybody should have a member. Everybody should have a member. And if you do have a member, and you go ahead and grab a hold of that, you can share your member with other people. Now, you can share your member with multiple people at once by doing membership gifting. So you can gift a member to any number of people in the chat. And it's a great way to participate in the show and support it. If you don't want to have a stupid message attached to it, and you want to help people out who are less fortunate than you, because you've already got a member and they need one. And that's my philosophy. Give members out like crazy. Official Chris Tony says, you're like the Pee-wee's Playhouse of LawTube. Not an insult. I love Pee-wee's Playhouse. You should do some holiday specials. Maybe. Sleeping Psychopathy. Nick wants to see more members. Who doesn't? Oh my gosh. I was watching House of Asher, the new Spartacus season or spinoff or whatever. And I watched the first 2 episodes now. And it's okay. It's very woke. Like the new King of the Arena is a black woman or will be. That's who they're grooming to be the new thing. But it's okay, that's fine. But she did hand rip off a guy's penis in the second episode. Spoiler alert. That did happen. It was very funny. And yeah, so I'm with it. I'm with it so far. But yes, we all want to see a good member. And look, she grabbed a member. She didn't have one. She didn't have a member, and now she does. She grabbed it. She got her own. You too can grab a member here. No one has to bleed out for it here. It's called Ben Hur, not Ben Him. The link isn't working, huh? Did Jay Liebgott screw that up? Where did it go? It looks like it's working. Oh no, it's broken. It's broken because J-Leeb got added dots after it. He tried to put an ellipses there. I should put you in timeout, Lieb got. I should put you in timeout. You wonder if that is even possible. Maybe with some good nails, you could get a good grip. Yeah, I don't know. Like, I've never ripped a guy's wiener off or anything. I always handle them gingerly. I kid. I'm very rough with them. But I've never done that. And I'm sitting there, I'm like, I don't think the physics matched up. Because she's like skinny. She's skinny. All right. Here we go. What else do we have? We have Coding ATC says, since I'm an elephant that needs to lose weight, I just got done swimming. Now I get to listen to the crazy lawyer. I'm sorry. I think you misidentified as an elephant, you fucking hippopotamus. The thing about hippos is they can't actually swim. Hippos are just so depressed at how fat they are that they try and commit suicide by drowning, and they can't. They're too buoyant. Vailnid, member for 1 month, says your outfit pales in gayness to EVS's wardrobe. That's true. That is true. Kimberly Campbell gifted 5 memberships. So 5 new members in the chat. Love to have you. You guys are wonderful. Should we have a member counter going? Why does it keep changing my shit up? All right. So I don't know why it keeps changing the style of my name tag down there. Let's do this. So we'll go up. We'll do this one. And we'll go new members 5. We've got a membership counter, and we'll also have the super tip link there on the bottom. Let's see. I am trying to get a couple new voices. I am trying to get a No Tie Bronca voice put together. There's another one. Oh, I want an RFK Jr. one. Right? I want the RFK Jr. voice. So it's like, we want to talk about how the American people are fighting against infectious disease by maintaining virginity. Like, we want that. We need to have that. It'll be really disrespectful and horrible. But to do it, I might have to do the impression, because I don't know if Super Tip will actually, he's a prominent political figure. I don't know if they'll actually do it on their own. So I might have to fake it. Trump voice, same story. They won't do major political figures. So eventually I'm going to have to do impressions of every politician. We need a Jesse Ventura one. So we, those take a little, it's hard to maintain. It's hard to maintain for 10 minutes. Like usually I'm done much faster. And so it's hard to keep that up, hard to keep it up for 10 minutes. But we may have to do that and do Trump impressions and stuff like that and get really wonderful voices put up. An honest doubter bringing me back says, want to buy / want to trade for a fungi tunic. This is not made. This is not a Mike and Id. Chininator 4426 says, hey, Nick. Hey, what's up, buddy? How are you? Shut up, I can cook. Cookie says the super tip link is not working. Plus, Art cannot cook. I have an urge to call Elliot Ness on Nick. You can call him, but he won't call you back. Kimberly Campbell says, did you hear that Kyle Rittenhouse got married? I did. What's the chat's opinion on a couple things? Guns in your wedding photos, right? Like, I think it's cool. Looking back, I'm now like remorseful that I didn't do that. I'm going to have to tell Lady Raggeds that I'm going to have to remarry her so we can have guns in our wedding photo, but I'll have to wait till probation's over. It's going to be a long time. And then the other thing is the first comment I saw, because like I retweeted it and someone's like, yeah, but what about those tattoos though? Like, whoa, wait, what? Like, that's not your girl. Like, that's Kyle's. Like, what do you care if she has tattoos? It was very strange. With that. So I don't know. But I did hear he got married. I'm very happy for him. I'm really excited to see what he does next. Chris V. Clements has been here since Rittenhouse, but got my membership when everyone clutched their pearls without having the facts. Excited to watch trial with you again. That's Chris Clements, 20 months. Oh, yeah, right. Right there. So you joined up at the time that it was all going down. That's awesome. Thank you. And Uy 99, 23 months of membership says, hey, what's up? You can't unsee that she looks like Charlie Kirk. Someone pointed out now. Can't unsee it. I mean, I thought she's cute. Like, good job, Kyle. He's looking better. You know, back when the whole shooting happened, he's so young. Like, he was 17 or whatever. Someone needs to redo that Taylor Swift Betty song, but make it about Kyle Rittenhouse. The only reason I say that is because the line from the chorus is, I don't know anything. I'm only 17. I don't know anything, but I know I miss you. It needs to be, I'm only 17, ain't got much training, and I won't miss you, or something like that, right? Like, so he's gonna, because the only person he missed was a black guy, but it was nighttime. Probably couldn't see him.
Kirk is going on vacation as well. First, he's coming to me so I can taste that sweet meat. Then he'll be traveling to Africa to rape a virgin to cure himself of AIDS. Fucking dick.
Jesus Christ. Seems very rude of him to do that.
If you grab a member today, you can let it hang out later in member-only streams.
That's true. That's true. Member-only streams are very important. Farmtown Flippers, what mic am I using? This is an RE20. It's, what's the brand name? Electro Voice. Electro Voice RE20 is the mic, and the interface I'm using is a Rodecaster Pro 2. So, you know, this is an XLR mic. You do need an interface to put it in your face.
I'm making Alice in Wonderland themed chocolate covered Oreos. They're like 200 calories each. Gonna make everyone at my friend's daughter's first birthday fat. Perfect. Micro peen.
All right. So this keeps up. We may put up a micro peen counter. I have a way to check it. I think we're at 2 so far. But this is serious stuff. We've got an assassin on the loose.
Bitch.
Just
bitch.
Thanks. I appreciate that.
Nick, why are you dressing like a 1970s drug dealer? Also, Art, the clown cannot cook. I am sleepy. Taylor Swift with my man, the loose woman.
Wait, is your man the loose woman? Is your man Travis Kelce? I don't know. I'm not sure. No, I thought it was really funny to start dressing like a drug dealer, like a stereotypical movie drug dealer, because everybody, especially like when I came back and everybody's like, "You're on drugs." It's like, oh, nope, no. The government put a stop to that, which is fine. Like I wasn't happy with it at first, obviously. Like, don't tell me I can't drink and snort a bunch of stuff. Like I want to do that. Now I'm like, whatever. I do think I think I'm able to keep track of the show a little bit better now than I was. You know, with I always call alcohol a social lubricant, and with that social lubricant, you don't have to really keep track. You just kind of flow from one thing into the next, but it gets sloppy. Like you get past the point of the superpower, and then you get straight into it, just kind of being a fucking slurry mess, but you can't hear it, right? You're drinking. So anyway, that's not around. Here we go. Like, stop this. We got to talk. My background keeps getting taken away. It keeps getting taken away.
Beta.
Exactly.
I just need you to be black and a female.
Perfect. Cookie, that's you. Black and a female. Okay, so here we go. Nick claimed a Polish pimp's luggage, no biggie. You know he stole that from a Slovakian anyway. So anyway, here we go. we are going to watch this this hearing. This is the hearing of Tyler Robinson. Happened today. I have not watched this. It's about an hour and a half long. I'm going to try and let it play through. And if there's any breaks, we'll skip them. My kid's still doing blow without me. No, they do it with me now, of course. Look, that's the last joke you get about my kids. If you say another one that's rude or whatever, I'll remove you. Like I don't need to invite you into my house to do that. You can make fun of me all day. It's fine.
Art just said he will sue me for defamation, but he does not want my EBT card. The pale, hairy, nun-cooking white man.
The way she said that, it was nun cooking. Okay, so it's look at this guy. No, he doesn't look like a creep murderer at all. Like, what the fuck? Why would we suspect that this guy might have shot someone? I don't know. Making these weird fucking faces. There's no audio yet. So we're going to skip ahead until there is, of course. I don't want to sit here and watch this guy twitch around.
Nick, you know damn well Cookie only wants them pink tips. That girl loves her some white men.
She does. Cookie likes pink mushrooms. He does. Holy shit. Janvier says he's got a massive chin. I didn't notice, but look at this thing. It is huge. Like it's funny because it's simultaneously a massive chin, but like a recessed, like beta line, jawline. Like this is weird. It's like the Eiffel Tower. It's retreating just really far from level.
So glad I'm awake for a life for once.
Yeah, no kidding, Lily Smith. I've been frustrated that you haven't been here. Oh. What is the cameraman doing? You trying to check out the pores on his nose? Goodness gracious. Ladies, complexion tips for this man are welcome. REQ says, please don't kick me out yet. You listen here. You asked me not to kick you out, and that's the first way to stay. Hold on. His lawyer, she did like this. Whoa. I'm sorry. I thought he was sitting behind a barrier. But turns out the Great Barrier Reef is here representing him with a... God, that Microsoft Surface looks so small in those large, capable hands. What if he didn't do it? He might not have. I want to know how they defend this. Like, this is one of those things. But, you know, there's no real losing proposition here, right? Like, this guy, it's a public assassination done at a public event, puts other people in danger. It's terroristic in the fact that, like, you know, it causes people to be in fear being at public events or being public speakers. There's all sorts of problems with it. This motherfucker is going to get the max sentence if he's guilty. I mean, there's no way it's going to be like, well, you're a first-time offender. We'll give you 26 months, and then you'll be out, free to murder another person. So we're going back. Part of the strategy may just be, like, there's no downside proposition to the trial. So go for it, right? Like, that's a thing that people do. A lot of people who, you know, where the death penalty is an option, you know, or life in prison, you know, they're like, well, if the plea agreement is for life in prison, then fuck it. You know, we're gonna take it to trial. Just
we're going back on the record in case 25.
What state is this in? Was this in Colorado? I can't remember. Or no, Connecticut, right? Was it Connecticut? Fuck. Hold on. Where was this? Illinois. Wait, no, that's where he was born. Utah. Oh, that's right. Like Sally was saying that she should try and get a media pass for it. Because I think she's out there. Somewhere around there. Who knows? It's on her Twitter. I didn't dox anybody.
1-403-576.
Echo alert, yes.
Utah versus Tyler James Robinson. I note the presence of
This judge has a soft ass voice. I'm going to crank the volume up a little bit on the stream. Hopefully counsel doesn't come in super hot.
counsel that previously entered their appearances. We have come out of the closed session and concluded that business. However,
This girl is quiet as
became
fuck.
aware of an event that happened before.
Okay, I am bringing up this a little bit here.
And my understanding was during the open portion of this hearing earlier that there was a violation of the standing decorum order as it relates to transmission of these proceedings. I want to hear from counsel, and then I will make a ruling concerning that.
So standing decorum order. So this court has an order, a standing order for decorum in the courtroom, which probably says that without the court's express permission, transmission of the proceedings, any sort of recording or broadcast of them is not permitted. And it looks like that was an issue. Hold on.
Nick, why are they asking if I'm in YouTube chat? Did a limp block me?
No, you're-
Also, Art the Clown cannot cook.
Cookie, you're in YouTube chat. You're there.
Utah.
Utah. There must be other feeds. There are. I didn't want to go find them. I was hoping to- Hold on. We'll see. Maybe the judge is just low for now. We'll check.
Shortly thereafter. Ms. Visser.
Thank you, Your Honor. I'm referring specifically to Rule of Judicial Administration.
Holy shit. This is so quiet. I'm going to find a louder stream. Give me a minute. Give me a minute. Let's see. So that's ABC 7 Chicago. We don't want to do this. Let's do this. You are watching Court TV.
Business. However, the court became aware of
There we go. That's a little bit better.
an event that happened before.
Well, hopefully this should be better volume for you guys.
And my understanding was during the open portion of this hearing
Shizzy, we got an
earlier
incoming raid?
that there
Or
was
Shizzy
a
raid
violation
That'll be
of the
fun.
standing decorum order as it relates to transmission of these proceedings. I want to hear from counsel,
Because
and
I am
then I
gonna
will make a
come.
ruling concerning that shortly thereafter. Ms. Visser.
Thank you, Your Honor. I'm referring specifically to Rule of Judicial Administration 4-401.01. This gives the court discretion to terminate or suspend electronic media coverage at any time without prior notice, if the judge makes particular findings and that the specific circumstances warrant it. It is our position, the defense position,
You
that
can hear-
there has
you
been a
can't hear me over
violation
them?
of
That's
the
gotta be
decorum
wrong.
order. It is our understanding that those live streaming this signed and declared that they would follow the decorum order, and they violated it. So we are requesting a sanction. We believe these court's orders are binding and they need to be respected. We also believe that it threatens my client's right to a fair trial. It's the whole reason we filed a motion in the first place to remove his shackles. It's our understanding that his shackles are visible. It is also our understanding that potentially some audio from counsel table was heard. We are definitely taking more measures on our own to ensure that that does not happen again. But there has also been some filming of computers and materials at counsel's desk. that's entirely inappropriate. And I think everybody in this room will agree that's entirely
literally
inappropriate.
was just able to see
So we are asking for
counsel's,
some remedial
laptop
measures
there.
here. We're asking for it to terminate for today, and we can proceed after that.
Thank you, Ms. Fisk.
Okay, so she's basically saying some stuff was broadcast from the courtroom in violation of the court order, and there is something that gives power. Like there's a rule that the judge may terminate the broadcast of proceedings at any point, which of course doesn't mean that he has to. Doesn't mean that he has to, and that's why they're asking for it here. So we want all these. We want it terminated for the day, and this is separate from the issue of will it be terminated from later. This is just for today's proceedings. So,
Sir, to the state.
now we'll see what the state
Your
says.
Honor, the state, as stated earlier, we believe that the court's order was very clear, and if there has been a violation of that order, then we agree that there needs to be some measure taken. We'll leave it to the court to decide the appropriate response to that violation, but we agree that any violation of the court's order needs to be addressed.
Thank you, Mr. Ballard. To the press, attorneys for the press.
Your Honor, Jeff
Fake Glenn Beck incoming. He's here. Don't worry. He will cry.
Hunt for the media interveners. This is the first time that we've heard about the violation. We've not had an opportunity to look at the video or investigate the audio or look at the capture of the computers, but filming of the inadvertent filming of the shackles. I did talk to the pool photographer. My understanding is that there was a zoom out shot that did inadvertently show the shackles. That was improper.
Okay, so what they're concerned with is the prejudicial effect of showing the alleged assassin in handcuffs, and this is a common problem in any case where someone comes from the jail or needs to be secured in the courtroom. You have to balance the need for facilitation. Oh, excuse me. Facilitation of a safe courtroom. You have to balance that with the trying to keep from prejudicing the defendant and their rights, and to put someone in a jumpsuit or shackles or chain them or put like one of those Hannibal Lecter masks on them, it makes them seem more dangerous. It makes a negative impression. So that's a problem, I guess, and they don't want that to happen. Now in this case, it's a little bit silly to be like, oh yeah, it's not going to be the footage of Charlie Kirk fountaining blood out of his neck from this guy shooting him that's going to prejudice him. It's going to be the shackles that are holding him to the table. Shizzy Wiznit or whatever rated the stream. Shizzy, thank you to the Raiders. May you be better at watching than the Raiders are at football.
Proper. That was inadvertent, and we apologize for that. They've taken measures to make sure that the pool video that is disseminated to the rest of the pool does not contain any capture of the defendant in the shackles. We can't do anything about the live stream, of course, but we can control what the rest of the video is that we capture and disseminate. So that is being done. The audio for counsel, my understanding is the only audio that they picked up was from counsel's microphones. I don't have any further information about that and whether that's a violation. Filming of the computers.
It's not. If counsel's stupid enough to be talking with live microphones in front of them, and then the media happens to pick up the replay of the live microphones, that's counsel's fault. Counsel needs to get some fucking mic discipline. All you have to you just mute it, right? Like, that's what you do. There's a button right on the fucking mics. You just mute it when you talk about anything important.
Is not a violation of the decorum order if you...
Grifty sending 5 more memberships. Thank you, Grifty, for putting your member into 5 wonderful other people. Now they can spread the member cheer. If you get a gifted sub, guys, make sure to thank the person who gifted it to you. Very cool of them to do that.
If the capture can show the document that counsel is looking at, then that is a potential violation. So I just don't know how much detail the shot is that is of concern to the court. But I'll just say that We reiterated as soon as I heard this from Mr. Ballard with the pool representatives that this is very important to follow to the letter of the court's EMC order. They understand their obligations. They take that very seriously. They're not perfect. Mistakes happen. We're trying to correct as much as we can on that. But we think termination is not an appropriate remedy. An admonishment from this court, a reminder that they need to follow to the letter the court's EMC order is appropriate. That's the message that counsel has delivered to the media representatives and the pool operatives, and we think that is the appropriate remedy.
Thank you. Thank you.
I just want to make it clear, we're still receiving messages that shackles can be seen on the live stream as we restart it. So it's still a problem.
Still a problem right
Thank you.
now. I'm looking at the shackles.
I appreciate all parties weighing in on this important matter.
The only party weighing in on the important matter was that big chick at the defense table. Grifty says, y'all are welcome for my member. Truly my pleasure and yours. Grifty is a problem. He's out there putting his member in everyone he can find.
And I find that there was a violation of the standing decorum order that was in effect as of October 30th, 2025, based off what's been proffered, as well as the EMC order signed by the court.
Fletcher Boy gifted
As
5
previously
memberships
stated
also.
by Ms. Visser, the court does have discretion in determining whether to terminate the broadcast of these proceedings. And again,
Look, Fletcher Boy, you guys got to be jealous. When your member is so big that it has to go to 5 other people, big member, Fletcher Boy, sharing the love, flesh for everybody. I had to pause the court because I want to hear what he's going to say. I'm going to actually back it up just a second. He does find that there's a violation, and then now he's got to, of course, go ahead and determine what the proper remedy is. It's within his discretion to do so, and we'll see what he says. See, this type of stuff to me is actually kind of interesting because you have common law principles that go across multiple states, but then you have state-specific statutes and you have state-specific rules of practice. And then you have courtroom-specific rules for the courtroom. The judge has like just a set of things like this is how I facilitate my shit, and you're going to follow it. And it's just really cool to see like the differences in how courtrooms play out. And by the way, what's up, AJ? How are you doing? Welcome to the stream. Nice to have you. And we've got Chris V. Clements. Chris V. Clements. Chris, that sounds like Crispy Clements. Are you a cereal? Chris V. Clements gifting his member to someone else. Very nice of you to do that, Chris. Thank you. Whoever graciously received Chris's member, make sure that once you're done recovering, you breathe for a little bit and you wipe some of the sweat off. You go ahead and give him a thank you. Very nice of you to
whether
do so.
to terminate the broadcast of these proceedings, and again, if there's specific circumstances warrant such action, that the court would need to make findings in order to do so. I find that excluding the cameras from the courtroom would be disproportionate for this hearing.
Yes.
I find that making it very clear, first, that the transmission cannot begin until court is in session and must end as the court ends the session, and cannot be filmed before or after. The filming of, as previously stated in the decorum order.
Okay, so this is interesting. So he's tailoring down, the press has a right to report on this stuff, and they also have a free speech right to report on it how they want. And so anything that's a restraint on how they do that has to be pretty carefully sculpted and crafted to not go beyond the bounds of constitutionality to achieve the purpose for which the court is empowered to achieve, basically. In this case, the concern is about the shackles and the prejudice that it may have on a potential jury pool to see the accused in, who is presumed innocent. He is innocent until proven guilty, but to see him in shackles or to see him in a jumpsuit.
Hackamania promo code come licking jailhouse hero.
The promo code for Hackamania is RL, not promo code come licking. He's a jailhouse hero, got cum in his eyes. Sorry. Since we were so graciously interrupted by Tardic X. Yes, you can, by the way, you can come see me. Emphasis on the C. You can come see me in April of 2026, April 10th through 12th, Hackamania in Las Vegas. Get your tickets at hackamania.com / and then use promo code RL. Promo code RL.
MC must be followed to the letter. The sanction for today is that this camera will be relocated away from defense table to where the bailiff is, where Jeff is standing over here. I want to immediately address any possible transmission of shackles, as previously stated by counsel, and remove the possibility of capture of screens of the computers at defense counsel's table as well. In addition, if there's further violations of the standing decorum order, this court does have the right and will exercise termination of broadcast of these proceedings. And I simply want to put all parties on notice, to the press, to all parties, that this court takes this very seriously. While the court believes in openness and transparency, it needs to be balanced with the constitutional rights of all parties in this case. As such, we will take a brief recess to allow the relocation of the camera and to the place indicated by the bailiff, and then we will resume these court proceedings. I am anticipating this take perhaps 5 minutes. All right, and then we'll come back on the record and handle the remaining of this hearing. I appreciate the patience of parties as we move forward. We are trying to do the best.
Oh, they disconnected the camera. I'm like, what the fuck happened? He said, I'm doing the best we, or whatever, we're doing the best we. It made me think of that song. What was that song? It's from the late 90s or early 2000s. I'm doing the best I ever did. Go away, right? Now go away. Who was that? I'm doing the best that I can. Fuck. Who was that? Was that Static X? Godsmack. That. Thank you. Jesus. I should have known that. Whatever by Godsmack. Good song. I liked Godsmack. I'm not the one who's so far away when I feel the snake bite into my fuck you. You know what? You're a piece of shit. Whoever sent this in.
Nick, stop telling people they can see you in April.
Stop it. God damn it. Yeah, Nana Bear, I'm just enjoying the time here. We're gonna fast forward ahead of time. One second. We're on a short break. Oh, hey, here we go. On the record. What the fuck? Or 305. Here we go. So here we go. We'll get.
Let's move to the next matter before us.
You guys should not send such disrespectful super tips or whatever. Only respectful ones.
And of course, I'm looking for my notes, and they've disappeared, but that's okay.
Godsmack wasn't a bad live band. I feel like I saw them once. I think it was at Family Values Tour in 1999.
All right. Let's go ahead and address the state's motion to amend or clarify the publicity order. And I'll hear from all parties. And I know it has been briefed, but in responses, but I'll hear brief argument, and then we can go from there. Mr. Ballard.
98?
Thank you, Your Honor. With respect to this motion, I think as we've expressed in the past, everyone in this room shares the same goal, and that is to ensure that there's a fair trial that happens in this case. And we recognize that the court's pretrial publicity order is intended to further that goal. And again, as I've stated before, the state plans to try this case once. The state is also committed to complying with its ethics.
Holy fuck. No, I think it was the 2001. It was the 2001 one that I went to. So this is really important. Yeah, it was 2001 Family Values Tour. Was Stone Temple Pilots, which was also I think that was their number 4 album release. Linkin Park, Stained, Static X, and Dead Z. That's a good fucking show. I looked back on all the like concerts I used to go to in the late 90s and early 2000s. 93 X Fest, and then Ozfest, Warped Tour, Family Values Tour, and they had this one show called the Clambake Festival. They're fucking great, man. I look back, it's like, whoa, this concert would cost infinity dollars in 2007, but I went to them in the 90s. Your sisters went to that? You were only 11, so you couldn't go? Imagine waiting so long to be born.
You can see him in April shit. I mean, Las Vegas at Hackamania in April shit. I mean, in the month of April.
Sean McDonald, you're a menace. You're a menace, I say.
Ethical duties with respect to pretrial publicity. We have
Frenchie
complied
Mom,
with those duties. We will continue to comply.
Frenchie Mom says, hiya, Nick. No Kurt tonight, thank God. You better stop. You keep talking like that, and we will go straight to Kurt.
With those duties. The issue we bring before the court here is that there's one portion of the pretrial publicity order that can be interpreted to reach beyond those ethical requirements and have the effect of being what would be an unlawful order, an unlawful prior restraint on speech. And our goal, therefore, is to get an order that's clear, that's lawful, and that the state has the ability to comply with. And the issue with the order that the state has is the use of the term witnesses in the order. We believe that term's vague and ambiguous. Does it mean anyone with relevant information about this case? Does it just mean those people that are going to be subpoenaed to testify in this case? Or is it limited to just the prosecution team? And I think as we've expressed.
Peachy says, any chance I can get you to have you imply I'm young when in fact my youth is in the grave? Well, look. John Wayne Gacy put youth in the grave, and there's nothing wrong with that. So I don't know what your problem is. You were 11 when I was going to concerts after high school. You're fucking... God. These people, oh, I'm so old. I'm like, oh, how old are you? Way younger than you. Fuck you.
In our filings, we believe that the court intended that term just be limited to the prosecution team because that is the way that Rule 3.8 reads.
Weird Al's a
Rule
good show.
3.8
in the 80s.
Of the rules of professional conduct that deals specifically with requirements for prosecutors talks about investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor. So in other words, the prosecution team.
Mine was Air Supply.
And there's no rule or case law or statute that expands the prosecution's duties beyond that group, the prosecution team. So with respect to clarity, we're seeking clarity as to what exactly does the court mean by witnesses. And we think the court just means the prosecution
Crash
team,
test dummies.
because if that term stretches beyond just the prosecution team, then the order is written, we don't believe is a valid and lawful order, because it would result in a prior restraint on
Fucking crash
certain
test
speech,
dummies.
and at the very least would have a chilling effect on that speech. If the prosecution agrees that we have an ethical duty to take reasonable measures to make sure that those who are identified with the prosecution team are alerted to the requirements of the court's order, and to make sure that they do not make a statement that the prosecutors themselves would not be able to.
Lisa Wicker asks, dude, what's happened to you? A lot. A whole lot. What's happened to you? How you doing?
Make a public statement.
You saw Oasis?
But
Are
if
they
the order
still
extends
playing
beyond that,
Wonderwall?
then we have concerns, because a prior restraint is an order that forbids certain communications in advance of the time that they are to occur.
My vape looks like a flask.
And as the Court of Appeals has recognized, the Utah Court of Appeals has recognized in State versus LM. And widespread publicity in a case does not itself justify a prior restraint.
Correct.
The United States Supreme Court has recognized in Nebraska Press Association, there's no justification for a prior restraint unless it's clear that the further publicity, unchecked, would so distort the views of potential jurors that you couldn't find 12 jurors who could be fair and impartial. That's the high standard that applies in this case. And so in order to apply a prior restraint to persons...
He's like, I'm going to fucking assassinate you next.
I saw NSYNC when I was 10 years old. P. Diddy and Busta Rhymes opened for them. Not even kidding.
That was back when...
I wish I could go to a concert with you, but viewers and funds are vanishing.
Big stupid.
Venmo, Cash App, PayPal, EBT, or green stamps.
Beta cuck.
Beta cuck. Streamlabs, PayPal, Venmo, Instagram, or whatever. OnlyFans. Someone had caught my attention. Oh, MPOW, thank you. Destiny Rose. I always wanted to see Evanescence. I don't think I ever saw them, unless they were at a festival show but I don't think so. I like Evanescence still. Trying to think. See, I've been to a couple shows like against my will that I went to with my parents. Like I went to a Jackson Browne concert. I actually kind of like Jackson Browne brings me back to my childhood. And so, because my dad used to listen to Jackson Browne in the car all the time. So, I went to the Jackson Browne concert. It was pretty good. He's a good performer. So there's some shows that I've been to like that. I don't really remember them a lot. I saw Bloodhound Gang. I liked that. But I've seen Stone Temple Pilots 4 times. They're my favorite band. I think still, I don't know. I can't quit them.
Beyond the prosecution team, the court would need to engage in a very detailed and demanding analysis.
Poison?
The court would have to make a factual finding of necessity, that the speech that would be restrained poses a risk of material prejudice to the ongoing judicial proceedings. The court would need to make findings that there are no less restrictive measures, and that the prohibitions are likely to prevent the potential prejudice, and that whatever prohibitions this court decides on are very narrowly tailored. And
so basically what he laid out, if you follow the people I follow on Twitter, sometimes they talk about prior restraints, and this is a prior restraint, right? To request a lack of cameras in the courtroom, to have no cameras in the courtroom, in this case, would be a prior restraint. So the court would be restraining something from happening before it has the opportunity to happen. When that prior restraint implicates a fundamental right, particularly typically a First Amendment right, like the free press, or freedom of speech or freedom of religion, any of those things. The appropriate level of scrutiny that's applied to review by the Supreme Court is strict scrutiny, which means that the proposed prior restraint must pass muster against strict scrutiny. And what that means, it has to be a compelling government interest. Now that kind of like is worded differently depending on what branch of government and the context here. So the context here is it has to be the compelling government interest, which means it has to be something that the court not only is able to do, but is something that it is in the compelling interest of the court to do. Not just like some interest of it. It is the court's purview, priority, very important to the court, right? So in this case, preventing prejudice to a defendant is obviously in the court's purview. The court has not only the power to do that, but it is a primary interest of the court is preventing prejudice. So you have that. Now, once you have a compelling government interest that's satisfied, you then have to have it has to be narrowly tailored to achieve solely that interest without sweeping up other constitutionally protected activities. One of the ways they talk about that is what he's doing here is it has to be the least restrictive means. And that's a test that the Supreme Court developed, the least restrictive means test. So it has to mean that the methods being used are the least restrictive possible methods. There's no other less restrictive alternative that they could use that would similarly achieve the interest. If there is a less restrictive method that can be identified and still achieve the same purpose, then the court is obligated to not use the proposed method, but the least restrictive means, right? Like, so that's what he's talking about here. And this is what they have to do. He's laying out the burden that the defense has to overcome if they want to keep cameras out of the courtroom. And he opened up very strong on his statement. He says, like just because something is widespread publicly available, major national news story doesn't mean that you automatically get to ban it because, and the reasoning there is like the more widespread a story is, any coverage will then disseminate out in theory to inseminate a larger audience. And it's really important to minimize the amount of pre-trial exposure to prevent potential jury pool prejudice. But there's kind of like a double-edged sword with how famous something gets because typically jury pools are localized. And so you really just are restricting the dissemination of information or prejudice in a particular area, like a geographic area where the jury pool may pull from. But once it gets to be kind of a ubiquitous nationwide story, like it doesn't really matter. It's not like the particular area is particularly situated against the rest of the nation. Everybody knows about this assassination. Who's going to know about it, right? Like the people who know about it and care about it do. They already do. And further dissemination by the court isn't going to cause further prejudice against those people. I think I saw someone in the chat say they're going to have to find a jury pool that doesn't really know anything about it anyway. And that's true. That's what they're going to have to really do. And so like trying to limit the amount of media exposure on this case is, one, it's going to be impossible. There will be tons of commentary out there. And two, there's no special ability to stop it from being disseminated within the jurisdiction. And without those things, like there's really just there's not a lot of point in trying. And then it actually further starts to work against the idea of banning cameras in the courtroom because how much this will be talked about with closed doors means that actually having a video and audio record of the facts that is authentic, or is about as authentic as it can get, live coverage, will actually ensure that the appropriate narrative about the factual procedure that's happening is reaching the public rather than just a bunch of like Candace Owens stuff or that was rude. But you know what I mean? Like it avoids conspiracy and gossip to the maximum amount possible. So again, his lawyers are trying this, and I don't really know why. Like, I'm not sure. Maybe there's some particularly embarrassing stuff, but it's like, bro, you're about to go to prison for the rest of your life. Like, I don't know what could be there that they're trying to protect.
The best concert I've ever been to was Rush on the Clockwork Angels tour. Before Neil died,
So Rush on the Clockwork Angels tour before Neil died. Neil Peart, right? I'm familiar with some Rush songs, but I was never a huge fan. My uncle was a very big fan of Rush. But I didn't really like it. It kind of like I generation gapped that one just a little bit.
Did you see the DoorDash girl Olivia Anderson who did a B&E and spread images of an unconscious man sans pants was before the judge?
This bitch told her lawyer she didn't want cameras in court. The judge said, "Oh, you don't want to be recorded without consent. Film that micropeen."
Yeah, I mean, it's kind of funny because, like, I know another person who was, accused of and ultimately convicted of unlawful dissemination of a private image, who similarly was like, you can't show pictures of me in public. It was kind of funny. Yeah. Who knows? Lily Smith 09 says, it's true I haven't caught a live, but I'm still a member. Lol. Lily, we love having your member here. You share your member with us anytime. Life in General says, where the hell do you find a jury pool for this? Impanel penguins from the Arctic. I think, you'd be surprised just go on Twitter, man. No, go talk to somebody about, just go down the street, be like, hey, did you hear about Charlie Kirk or whatever? And they'll be like, is that the pastor? Like, they won't have any idea who he is. We kind of get into an internet bubble and a media bubble, and our bubble is full of like internet personalities, of media personalities, of political discussion. If you're in that world, it'll fill up very quickly. But the moment you step out of it and you realize, like, the guy working at the Amoco, or well, I guess BP, British Petroleum, or whatever, like he probably is busy. He maybe doesn't have time for politics, doesn't care. They find juries for all these things, and you'd be surprised who has no idea what type of stuff's going on, even in their own communities.
With STP coming up, I need to remind everyone that Pearl Jam will always be superior to Nirvana.
Gen X Medic, thank you. Thank you for not saying Pearl Jam would be superior to STP, because you would need the ketamine for that one. Like, you'd be in need. I would be putting your life in danger. You would be at risk from me causing you harm.
As the state has explained, the Spencer versus State case from the Arkansas Supreme Court that just issued earlier this year is very helpful, I think, on this issue in explaining
like you haven't gripped it firmly
the analysis that applies to various different people that might be associated with the criminal case. You have attorneys, that category of trial participants. Certainly the court has the highest degree of ability to be able to restrain the speech of attorneys, and in fact, as I've expressed, the ethical rules require that. But when it comes to trial participants, like witnesses, the standards are more demanding as far as restricting the speech of trial participants. And as
just a reminder that my speech is still restricted by the Stearns County Court in what may be the longest restraining order case in the history of human fucking kind. I'm still under a gag order. As to the details of that case, I only mention it because people do from time to time ask me to talk about it. I cannot do so at present.
The Spencer case pointed out, non-attorney trial participants, the court can impose a restraint on their speech only to the extent that the court first finds that any speech by those non-attorney trial participants poses a serious and imminent threat of material prejudice to the ongoing proceeding. And I think the court also needs to note that there are...
I have been under the effect of an ex parte order now for, I think, 5.5 months. 5.5 months. My speech has not been restricted as long. My hearing, after 3 granted continuances. The reason I'm under the gag order is because my hearing is technically still going on. We have not finished the hearing itself. Even though it was continued from when it was started. So anything about the hearing and the details and the facts thereof, I'm not allowed to talk about. But the procedural posture, that's where it is. That doesn't have anything to do with the facts around the restraining order itself or anything that was said in court. So I can mention that, but that's it. That's all I can say. And it's crazy how long this fucking gone on.
There are several people associated with this case who have very significant interests in exercising their First Amendment rights, in talking about how this case has affected them. And of course, can't say that one person's First Amendment right is more important than another person's. But there are certainly some people here who have
I love the artwork on my walls too.
Some people involved who have a larger or a greater interest in speaking than others. And so I think the court needs to take that into consideration if this order is meant to apply beyond just the prosecution team. And then finally, as far as making the order, so we need a clear order, we need a lawful order, and then we need an order that the state can actually comply with. And the state recognizes that there are serious sanctions that this court can impose for violations of a court order, as we've just seen. And so we want to avoid these. We want to avoid litigation over whether there's been a violation of the order. And as it stands right now, we don't believe that there will be any issues if the court limits the term witnesses to just the prosecution team. We can comply with that order. It gets more difficult for the state if the term witnesses then applies even broader at this stage of the litigation, for the state to be able to comply with that order, depending on how the court clarifies what witnesses mean. Does the court have any questions for the state?
No, thank you,
Okay, thank
Mr.
you.
Ballard. Mr. Novak.
Thank you, Your Honor.
Eric Clapton unplugged. Holy shit. Every father on earth
I'm going to try to
crying
be
to tears
brief
in heaven.
because our views on the propriety of the court's order.
Hold on. This man's profile needs an ultra widescreen monitor. Holy shit.
Trying to come to see you at Hack since last I saw you. I just had brain surgery, but seeing Duran Duran New Year's in Vegas. So we shall see.
Oh man, that would be fun. Tamara, that would be a lot of fun to see Duran Duran in Vegas. I would enjoy that. If you get to come see me in April at Hackmania, that would be awesome. I'm going to reach out to the Anime Matsuri people probably right after the new year and just see if they'd be willing to bring me in for 2026. I'd love to come down to Houston, hang out. It's been what, since 22? It was 23. 2023 was the last time I was there in Houston, and like it's still my birth city. I still have a connection to it or whatever.
Propriety of the court's order were set forth in a publicly filed document.
Ordinary World is a great fucking song.
Which, of course, the court has reviewed. And the first thing that I want to say is that the order that the court issued is not a prior restraint on any member of the public.
Won't I be on my own this time, though? Boring. Like, so without the other YouTubers? I mean, maybe. Who knows? I don't know what they want to do.
And it's certainly not, I think, as the state's motion suggested, some sort of a prior restraint on the press. This has nothing to do with the press. The order, as we noted in our papers, is directed at the conduct of and the court's expectations for counsel. So even if, under that order that the court issued, somebody who we could all agree is a witness within the court's definition of that.
Chris Clements. If only I could tell you about that 45-minute bio break. I had no idea it was 45 minutes. I swear. I thought it was like 5 or 10 minutes. Why do I keep stealing my kids' vape?
Made
They're not allowed to have them every time they
public
get one.
statements which implicated Mr. Rob.
It's like when your dad catches you with cigarettes. He's like, smoke the whole pack. Right? Like when I catch my kids with illicit substances, I'm like, I get to do all of it now.
Robinson's fair trial rights. The potential sanction is on the party who had a duty to make a reasonable effort to notify witnesses that they should not be doing so. If I represented a witness who was accused of saying too much publicly, the first thing that I would tell.
Why is my man standing like he's in a gym locker room putting his leg up on the bench to air out the junk? Like, stop it. You're not in a gym. Why is your leg up on the podium? Put your leg down. Stand like a man.
This court is the order isn't directed at the witness. The order is directed at the counsel for the parties. There may in the future be some theoretical situation where the court issues orders that control the statements or conduct of specific people, but this, or other than counsel, but this order is directed at counsel. And we have no, meaning Mr. Robinson's defense counsel, have no problem complying with the order. And we also think that we understand what a witness is when the court uses that term.
Okay, so death penalty is on the table in Utah. So I don't know if they're pursuing the death penalty or not. I saw it. Did you guys see that the feds are not pursuing the death penalty in the Luigi Mangione? They're not pursuing the death penalty in that case. It's crazy to me.
Oh, and Kurt's micropene.
His micropene is not been seen in many, many years.
So it is our view that the court's order...
They are pursuing the death penalty here. Good.
It's not overbroad.
I mean,
it's not vague.
I don't know.
Doesn't
I still don't even like the death penalty that much, but
the state or the state's attorneys.
So my problem, I always have to clarify this because, you guys are all like, kill everybody. No, I'm just kidding. I always have to clarify this because I used to be very, very in favor of the death penalty. And then I started to fall out of favor with the death penalty just with the amount of fuck ups that the government has. And when they fuck up, they don't get punished for it, but they fuck up and someone dies. And like that kind of sucks. I mean, going to prison for a long time on the fuck up is bad also, but you always have this like lingering chance that you might be able to get out if they can ever figure it out. And you can fight and fight and fight as long as you're alive. You know, if you're in prison and you get killed, you can't really fight anymore. Right. So I don't really like the death penalty for that main reason. But that said, I've always believed that the state has the right to do to the death penalty, that the Eighth Amendment doesn't preclude the death penalty. Nothing about the death penalty is cruel or unusual. Governments have been killing their citizens after some level of their perceived approved process since the dawn of time. So government unquestionably has a history and tradition of utilizing execution as a means of control for crime and other things. It's been misused by governments, of course. We have one of the better systems for it. It still makes mistakes. But I do believe that the state has the right to use it. And because of that, I'm always able to go, yeah, I can see it in this case, right? Like, if this guy is convicted, why wouldn't he get the death penalty? Like, we know he did it, right? Like, this isn't like a mystery. The problem with a death penalty case is like sometimes you get a death penalty and it's like there's no murder weapon or no witnesses at all, or circumstantial evidence, which is sufficient to convict. But it's like, is it sufficient to kill on circumstantial evidence? Those are two different questions. But so like this type of stuff, death penalty. Okay, cool. Like you shouldn't assassinate a political opponent. Like, holy shit. Or not even a political opponent, just a voice you don't like for the crime of speaking in public. That's insane. Also, pedophiles. Get rid of them. Go away. Get out of here.
Nick has been dressing like he manages the insurance offices of Recchietta and Associates, a.k.a. 4 Jews and a photocopier.
And I'll allow that, but not the micropene.
4 Jews, a photocopier, and 8 shredders just in case. Just in case.
He's a witch. I saw him cavorting with Satan.
He's a witch. Build a bridge out of him.
At some untenable position. And I think it's a little bit...
Please research because the feds
It's
are
a little
lying.
too simple to
This
say
isn't a federal prosecution.
witnesses are either
Or are you
everybody
talking-
under the sun
You're talking
or
about
people
Mangione?
who are under
This
subpoena
is
at the last
Utah
second.
prosecutors.
Because counsel have not only the training, but a duty to figure out along the way who the potential witnesses are and to notify those people. And yes, down the road, maybe there's going to be an issue and maybe an attorney on either side of...
Lisa MW says, can't believe Nick actually believes this crap. I'm shocked. What do I believe? Like I said, my personal beliefs on the death penalty, but as far as this case, like, if he's guilty, then, you know, I don't see why they wouldn't do the death penalty. But that's if he's guilty. Maybe he's not guilty. I don't know. I have no idea. I've seen Charlie Kirk fountaining blood out of his neck. I didn't know who this guy is. I'm perfectly willing for him to levy a defense. I'm curious how they're going to do it. I want to know. But like so far, like I don't have any particular reason to disbelieve the narrative, but come on, it just took me to McDonald's. I'm not sucking its dick or anything. Like it's just, this is my perception of the event so far. We'll see what the defense comes up with, right? Like, look, you want to tickle my tonsils, you're going to need better story than the nothing that I have. Like I said, all I've seen is him dying. I didn't see the shooter. I didn't see anything like that. We need to see the rest of it. Don't worry about it.
Litigation is going to have to explain to the court when a particular person did or did not become a potential witness in the eyes of that party. That doesn't make it impossible for the state to comply with the order. It just means that the state needs to be thinking along the way about who its witnesses may be. And that's why in our papers,
ACAB True Crime says, I mean, a dude killed another dude. There's nothing special about that to warrant the DP. Well, look, I mean, first of all, double penetration is an extreme punishment for men because first they have to be transed and then they get DP'd. And I don't know if I'm willing to have the government do that to this person. That being said, this isn't just someone killing another person. We're not elevating Charlie Kirk here. I mean, Charlie Kirk, obviously an accomplished, charismatic guy, whatever. Like him, don't like him, undeniably impactful. And that's not the impact here, though, like of the murder. The murder at issue, why it's different than other murders, took place in public. It's terroristic in its own nature. It's about political speech, not like a politician, but political speech. And it is about silencing speech and making people afraid to speak out on certain issues. You know, like Charlie Kirk expressed his ethos in public. And if you don't believe in his or subscribe to his, his messaging, that's fine. But if you were to spread your message, right, you should expect to not be shot. And that's why the death penalty comes into particular concern with this particular murder. Having it happen in public, in a high profile environment and setting for the purpose of causing people to not hold particular views, to not speak particular things, it goes against the core values of our country. But that's why the death penalty would be, and the state, right? Like, that's why the death penalty in this case would be on the table. It's not of a similar kind to, a gang member shooting another gang member in Chicago. Like, this is way different here. And so, like, I don't accept that it's a man, like it just can be described as a man killing another man. That's not the crime. Like if he would have gone and slit Charlie's throat in the bathroom, at a Mets game or something, quietly, like that'd be different. This happened in public at a Charlie Kirk event where he's doing the thing that he's known to do. He was a rising political force on the Republican side. And so I think there's sufficient details here to say, well, it's a little bit different than some other killings. Like it's not a jilted lover killing. It's not like a, like I said, it's not some personal beef or vendetta. Like it's a real, it's about the message of killing him too.
We refer to it as a potential lay witness, because we believe that the court intended it to go beyond members of the prosecution team, which are law enforcement officers, retained experts, retained consultants.
How many Mossad agents?
And we don't believe that that creates an enforcement problem. We don't think it creates a compliance problem. We noted in our papers, and I'll emphasize here again, that the court's order.
Okay, can we just torture him instead?
Sure, I don't care.
Actually places responsibilities on defense counsel that the rules don't. The rules have special guidelines for the prosecution, and the court has expanded that to include the defense.
Yeah, he's like Ben Stein without the jokes.
Problem with that. I also think that the standard.
And imagine if he roll call, if he did the Ben. Yeah, people say I sound like Ben Stein. We're gonna call roll Charlie. Like that'd be fucking brutal. That would be a killer set, pun intended.
That the state is suggesting for when a potential lay witness, as we've defined that in our papers, may make public statements that violate the court's order. The best standard is actually the one that we believe the court should look to, which is the standard set by the 10th Circuit, because as the state points out, it may be that there isn't any Utah law on this issue. So it seems to me that the closest source of authority on this constitutional question is going to be the 10th Circuit, and that's the case United States versus Tijerina, and I'll spell it. It's Tije.
Janie L. Vargas, thank you for the super chat, says odds of a plea deal to avoid trial. Think BK. Like British Knights, like the shoes. Well, if they're going for the death penalty and they offer him life in prison, the odds are, I mean, that's a compelling plea deal for a lot of people, even if it's life in prison without the possibility of parole. Right now, the posture is they're going to trial, so it's hard to say, because even life in prison may be an unacceptable outcome for this guy. You know, or maybe the guy wants the death penalty. Maybe he wants to be the martyr. You know, why did he kill Charlie Kirk in the first place? Now, I know he didn't, and like Candace Owens' gypsy servant did, or whatever. Like, I don't know. I'm just going with the public narrative. Like, if you want me to like embrace all the different theories about like how I know it couldn't have been a 30-06 or whatever. Look, they're going to get a chance to explain all that. The experts will lay it out, and you can buy it or not buy it at that time. That's fine. I'm not really interested in the counter narrative or the narrative. I don't give a shit what the narrative is in regards to reviewing the legality, the propriety of our court procedures and our punishments. Crime and punishment exists in both the concrete and the abstract. And, you know, Charlie Kirk's, this trial and the situation around his murder are two different things. So the situation around Charlie Kirk's murder, if you want to engage in like conspiracy theory, and I don't say that in a derogatory way, I just don't have a better way to put it. But if you want to engage in that conspiracy theory and talk about like all the problems with the public narrative and Turning Point USA and like his wife going out on the media tour and taking over the company and who might have other interests in it, sure, like go for it. I don't fucking care. Like, have at it. I'll sit there with popcorn. Like, I don't have time to follow it all. So I'll sit there and listen to you guys. And like, sometimes it's really interesting. Other times I'm like, okay, I don't believe that, but that's fine. Like, that's how this discourse works. And you'll never have all the facts on the situation, no matter what. You'll never have it all. That's one thing. But the other thing is this government narrative that's going to go to trial. That narrative is really fucking important in how the trial takes place. Even if it's false, Even if it is some like false flag, or if it was an intentional killing and an inside job or whatever, like maybe his wife found him on Grindr, like who knows what the fuck it is in actuality. Like that's a whole separate story to what is being presented in court and what happens as a result of that. And our freedoms don't rely on the Turning Point USA narrative or how faulty it is. Our freedoms hinge on what's presented to the court and how the court deals with that. And that's more my area. I'll engage in the theory stuff. Like I think it's interesting, but I don't, like, no, I'm not reading the secret documents and the protocols of the articles of Kirk's assassin. Like I don't know what all this shit is, and I won't. So if you want that from me, you won't get it. What you can get is this member, though.
I propose that if convicted, this man is given life in prison, and he is only allowed to eat meals cooked by Kirk.
Holy fuck, that's death by botulism. That's rude. That's mean.
Our INA 412 Fed Second 661, 10th Circuit 1969, where the court says
got my first real
that
bought it at the
constitutional balance between the First Amendment rights of a non-attorney participant and the defendant's right to a fair trial are properly balanced where extrajudicial statements present a reasonable likelihood of prejudicing a fair trial. That is a more protective standard than that which appears in Rule 3.6. And we think it's the appropriate standard which should be applied here. That's part of, as we've told the court before, a motion that we will bring because we actually think that while the court's order is wholly appropriate, it's not vague, it's not overbroad, it's not a prior restraint, it doesn't create
how dare you? Look at this fag on the
a lack
podium.
of clarity for the state.
It's very fucking offensive.
We would like it to be a little bit broader in other areas, especially concerning the standard to be applied and the definition of what is the prosecution team. But that's not germane to here. So we think that while we understand the state's concern, we think that their motion should be denied. I think at the last hearing, the court actually clarified verbally from the bench what it meant by a witness. And I think that's pretty close to what we described in our papers as a potential lay witness. So I feel like if I say anything more, I'm going to be reiterating again what's already in our papers. If I've muddled it, I'm sure the court will tell me and I'll clarify it. I hope I haven't.
Thank you, Mr. Novak.
Okay, thank you.
You know what's been muddled is that man's facial structure. What is it? It's parabolic in nature. Good Lord. The crown of your head must be at the same recessed point from the tip of your nose as the crown of your chin. Like, how do you have that much like chin but not a good jawline? Weird. He needs like headgear, some orthodontics.
All right, and we'll turn to the last matter. Anything?
And how dare you say he's low testosterone? It looks like he takes in tons of it.
Further, counsel?
Yes, thank you, Your Honor. I do want to point out that the court's order as it's written does impose limitations on speech. And the issue here is whose speech? Is it just the prosecution team members or does it extend beyond that? And limitations on speech are a prior restraint. The court's order says that
prior restraints, courts are all too willing to issue prior restraints. They do it all the time, more than just about anyone else. Like, I mean, courts make orders, so it makes some sense. But like, you know, Congresses, legislative bodies, city councils, even they don't go so far in proposing prior restraints with the level of flippancy and callousness that courts do. And the court's views are typically our job is really important, and the prior restraints are always temporary and will expire in a reasonable amount of time. Therefore, they justify them and say, you know, who cares if someone's speech is restrained for 2, 3, 4 years even, because, you know, it's temporary in nature and it's not overly burdensome, which is crazy for some people to suggest that a restraint on speech is not overly burdensome. Some people talk for a living.
If you look at page 2 of the order, it specifically talks about lawyers, that lawyers cannot make a statement that would
Let's come up with a new
violate
conspiracy
Rule
theory. Like, let's
3.6
start
and
a
need to
rumor.
inform witnesses
That guy is Charlie Kirk's
that
estranged
they cannot
son.
make similar statements, and then requires
He proposed to Charlie Kirk via email. Charlie turned him down and said, not only are you not my son, but I will no longer marry you after you said that. And then he turned on him and attached to the bullet. Attached to the bullet was a diamond wedding band that Charlie Kirk gave him. Of course, he delivered it via it being around his penis into his mouth. And he gave him that wedding band, and he was returning that wedding band via bullet to Charlie Kirk. And it wasn't actually Charlie's physiology that stopped the 30-06 round. It was the wedding band deflecting off of a bone shard from the vertebrae that kicked the bullet back out the front. Back out the front. And that's what happened. That's the motive for the killing. That's how I know it was this guy.
the parties
Let's spread that
to
around.
inform lawyers, excuse me, I'll just read it. Lawyers participating in the investigation or litigation of this case shall inform all witnesses, and then the list that I read, about the prohibitions contained in this order. So the order is prohibiting speech. And because if it...
SC Medic 71 over on Rumble says, poor guy, his jawline was fine until he had so many scrotums bouncing off of his chin. Fuck me.
extends beyond the prosecution team, it needs to have the findings that are required for that kind of prohibition on speech. That's what we're asking the court to do.
Thank you, Mr. Ballard.
Thank you.
All right. Let's turn to the final matter before this court, the motion for limited intervention and request for notice of motions to close, seal, or reclassify. And I'll hear from the parties on that.
How does that story still make more sense than Coke overdosing Juliet?
Thank you, Your Honor. David Ryman, representing the news media. Mr. Judd and I represent different groups of clients, so I'm going to invite him, if I miss anything, to weigh in after I'm done. But my intent, the issues are basically the same, so my intent is to address them for all of the interveners at once, and I'll be very brief. We have only ever sought, in this case, limited party status. That is what we do in every high-profile case that involves these type of closure issues. We are not seeking to be parties for all purposes. We are just seeking to be parties for the purpose of showing up and being heard, which we unquestionably have a right to do. We unquestionably have standing. That is settled law in Utah. And
oh, buddy, you will never convince me that you're not questioning. Not once.
And the filing, the last filing at least, that we got.
So what he's talking about, though, is limited standing for the media. The media's access to public trials. The media does have a right of access to public trials. It's been around for a long time. It's, the Supreme Court has laid out kind of how it works. The states tweak it a little bit, but ultimately, trials are presumed to be public, particularly criminal trials. They're presumed to be public, and they are public until the court finds sufficient grounds to restrict them from the public's view. And that restriction is sometimes limited temporally, since someone was getting on my case for saying temporally a lot yesterday. But sometimes it's restricted temporally, like, this will only be during the pendency of the case and maybe for some short period of time after. That's sometimes why it happens. The other time is that it happens is under certain statutes. There's no cases can have limited communication or even sealed proceedings because the nature of the crime in regards to the victim. Someone who's a victim of a crime that is particularly has some sort of embarrassing component baked into it, which typically, you're talking about sexual assault of a child, for example. Some states go, you know what, like those details don't need to follow this person around out of their childhood. So they find ways to restrict the dissemination of those details. The dissemination of those locals, you better keep going. I was going to say you better stop, but you better keep going. The dissemination of those details either by censoring the name of the child so as not to, attach a permanent record of their victimization to them. Sometimes they'll seal proceedings in the cases of rape or sexual assault because, again, those details, like that are relevant to the crime, so therefore would be public, may be very embarrassing. Like, for example, say someone was violently raped and it caused particular types of damage to their reproductive organs or their mouth or their anus, like for lack of a better way to say it. Those things happen sometimes, and that's not really the public's business or any particular person's business, and that shouldn't be a burden on a victim. Victims, in many, if not most, if not all circumstances, are not choosing to be victims of crime. They're not engaging in this thing. Now, sometimes, like they engage in an environment where their victim status is a product of their other criminal decisions, and maybe that kind of negates it. But that's why the court does this on a case-by-case basis. That's why it's very fact-specific. The law is consistent, and the law heavily favors publicity. That's what this is all about. But so the court can, or the media, the public media can always come in and request access to this stuff, and the court can grant them the amount of limited access that it believes is required to balance all these factors out. And that's what this guy's saying. That's all we want. We want the opportunity to come in, ask our questions, be heard on the issue of publicity, and then the court can decide. And that makes sense. That's reasonable. SC Medic 71 says another plausible cause: too much time in a vacuum, like hours spent sucking his furry boyfriend off. Jesus.
Have you seen the Prego Lesbo Candace pic? Maybe her hate is because Erica rejected her, not Charlie.
Could be. Maybe just mad at the white girl for not giving it up.
From Mr. Robinson's team that just came in.
ACAB True Crime says they also seal stuff to cover up the government not following the law. That they do. They do that from time to time. And, that's why having the limited access to media for them to ask the questions is important. Now, someone who's currently got a case around this subject, who is on the side of not making some things public, mine's a little different because the things that people want to make public about my case weren't actually involved in the case itself. They were not brought into the court. They were not brought into trial. There was some weird circumstances around it. We don't need to sit and dwell on it. But I have an interest in keeping some of those things private because it's not anybody's business. We didn't make it that business, and we're not disagreeing with the government on it. I pled guilty, case is over, that stuff, what doesn't matter, right? But in most of the cases where there's a cover-up, what they also try to do is try and seal the documents from even the defense, so they don't have it. Usually the defense and the media are on the same side of those issues because they're both trying to get access to the stuff that the government wants to cover up their bad actions. So that's how that usually works out. But sometimes it's a little different, like in my case.
I don't know if it was a couple days ago, basically gets there at the end where it says, look, if you're going to grant them intervener status, it should just be limited. That's all we've ever sought. And so the question that was raised in the only case that they cite, this FL case from the Utah Supreme Court, that addressed whether we wanted to allow full party status under Rule 24 of the civil procedure rules in a criminal case, they said we don't need to do that. The woman in that case just needed limited party status. And so in a way, we're not really, the state really hasn't disagreed with this either, but we're not really disagreeing with Mr. Robinson's team. We have explained in our papers that we've cited the court to extensive authority, saying that this is the procedure to use. It's the most efficient procedure to use. Otherwise, I don't know what exactly the suggestion is from Mr. Robinson's team that we're supposed to do from here on out, but it kind of sounds like just this sort of ad hoc show up anytime you happen to see something on the public docket that might affect the public's rights, and that's just not the orderly way that this typically happens. The other thing, as I've mentioned in our papers, that it does,
yeah, Fletcher boy, this
is
media
it allows for
Private.
the media.
My privates look like a useless mini bike kickstand.
Beta.
Sorry.
An appeal of a closure issue without having to rely on the court's extraordinary writ jurisdiction. And that was what they had to do in either Kearns Tribune or Bullock, where the media was not granted party status. And it is the situation that happened in FL, where they had to review her claim regarding records under extraordinary writ jurisdiction rather than invoking their appellate jurisdiction because she was improperly denied limited party status. So all of that authority supports the process that we are requesting in this case. We think it's the most orderly way to do it. And I'll end just by saying, there's been some discussion, and especially from Mr. Robinson's attorneys,
what's up, Sue,
about what rule it is that you need to do this under, whether Rule 24 applies. They seem to suggest that it doesn't. I will just point the court to two different rules that give you the authority to do what we're requesting, aside from Rule 24. Rule 24 is.
Got any in that vape? Are you saying THC? No, this is just nicotine vape. I can have a THC vape. I have a prescription for it. My probation officer gave me the green light. Like, as long as I have the prescription, for it, I can use it. If I used a THC vape on stream, I'd be asleep in like 20 minutes. So I don't. That's why you'll know if I'm. First of all, I'd just tell you because it'd be funny. But you'll know, like, if I was using a THC vape, I wouldn't be able to get through sentences without remembering how they started, and then I fall asleep right away.
In the civil procedure rules, but Rule 81, and particularly subsection F of that rule, says that the rules of civil procedure govern in criminal proceedings where they don't conflict with a rule of criminal procedure. That's the case with Rule 24. That's why courts in criminal cases
you smoke tobacco out of a pipe?
Have relied on that rule. The other one is Rule 31, and that's in the criminal procedure rules, and that gives this court the discretion, if it's not inconsistent with the rules, to fashion remedies and to deal with civil procedure, or it's not civil procedure, but rather just procedural matters. And so that is essentially what happened in the FL case, which is that, whether you do it under Rule 24, whether you do it as a judicially created remedy, it doesn't matter. It's the same. It gets to the same place, which is just that we are interveners for the very limited purposes that we've set forth in our order. We're not going to be here at every hearing arguing. We didn't take a position on the gag order motion that you just heard.
I do. I take a position. Gag me, big court daddy.
We are only planning to appear and argue so that the court has the benefit of someone who's representing the interests against closure.
They keep worrying about Rule 24. Tyler is sitting there, inmates, sink furry Rule 34.
Oh, man. THC vape makes me cough too much. Me too. And if I inhaled nicotine absorbs in the mouth, so you don't have to suck it down, at least from vaping. You don't have to suck it down into your lungs to get the little nicotine hit, I guess. But so for me, I just kind of in the mouth and out. I mostly this is a ice one, which has a minty sort of flavor to it, and it cools the inside of your mouth because my mouth is hot from all the friction.
Because as you know, and this is sort of why we're here today, a lot of time this just happens by stipulation. Because these, the state and Mr. Robinson's lawyers, they may not want to fight over a particular issue. And so it really is a situation where no one really represents that interest. And the purpose of this whole process is to give the court the benefit of the briefing that we've submitted and the benefit of arguments to represent the public's right to attend these proceedings. So unless the court has any questions, that's all I have.
Nicole says you don't have to suck it down, a phrase not commonly said by men. Wait, what men are you hanging around? Well, I guess, yeah, you do have to suck it. No, you're right. Fuck. I got that wrong. Damn it. God. I'm deleting my YouTube channel and starting over. See you guys on the flip side.
Thank you.
Thank you.
To the state, Mr. Beller.
Your Honor, as the state briefed in briefing on a prior motion, I think it's clear that parties have outside entities have the ability to intervene in a case as a limited purpose party.
What do we think about this chick's suit and her plastic watch band? I don't know about this. I'm not with it. And it's hard for me to tell with the lighting. Is the suit cream, white, or yellow? Like a really pale yellow? I think it's white, but her watch band seems whiter than it. She's got dead, hollow eyes. She's seen some shit going down. Is it off-white? It looks a little off-white. Eduarda says, no more drinking on stream. What the fuck happened around here? If I drink on stream, I'll go to prison for 21 months. So I have to not drink on stream. That's the way it goes. You know, the government happened here. Government's like, we're going to make everything better. Can still vape though. For some reason, in the no mood altering substances order, nicotine's not included. And approved prescription medications aren't included either.
When there's a statute, a rule, or case law that authorizes them to take specific action in a proceeding. And there's well-established case law that allows the media to intervene to be able to appear and be heard on matters of public access to court proceedings and to court documents.
You're going to give them ideas. Sorry.
And Rule 4-202.04
Dead, hollow eyes when I pick up my burdens.
Administration also make it clear that the media can appear and
wait, what?
Dead, hollow eyes when I pick up my burdens.
Yes, correct, Megan Fox Ryder. Thank you for reminding me. If you drink it all, you go to prison. Yes, I'm disallowed from having alcohol for the duration of my probation. But the reason I said drink on stream is because it'd be highly visible, right? But also, I am tested for drugs and alcohol randomly, by the state of Minnesota. They make sure that I am good.
do just exactly what they've done in the closed session that we held earlier. So it doesn't make them a capital P party to the case. It makes them a limited purpose party.
I'll give you a capital
and
P.
they certainly have the right to be able to do that. Thank you.
Proud liberal to you says for how long? Okay, so it's up to 5 years. Technically, I can get early release, which is disappointing for everyone, right? Like early release from the probation terms. Typically, that doesn't happen until at least half of your probation has been served. So it'd be 2.5 years plus a day. That's not an official rule, but it's a rule of thumb.
Thank you, Mr. Mallon. Ms. Visser.
You don't have to be sorry. You didn't do it. I did. It's my fault. But that's okay. Like I was bummed about it at first. Now I don't really care.
Thank you, Your Honor.
Okay, first of all, woman, get an iron. What this is not. Look at the creasing going on in this skirt. This is very, very bad. The jacket obviously needs an iron as well. So like this is not great. All in all, pinstripe power suit with a skirt. I'm not the biggest fan of this outfit. This is just a preliminary hearing. Hopefully she'll step up her game, right? For the trial, and she'll dress a little better. I mean, who knows? Like her co-counsel is taking up all of the fabric in the known free world. So maybe this is the scraps that were left over. I'm not sure. She's gay, so. Lesbians aren't real. Didn't you guys learn this yet? AJ says, I'll drink the bourbon for you. AJ, I will leave you to drinking the bourbon. You can tell me about it all you want. Just let me know how it is. The one thing that that is a little weird, we'll go back to this, because like I genuinely, I'm good. Like I'm good. I like whiskey. I miss it or whatever. And in the future, maybe I can have it again. Who knows? Like I'm not worried about it right now, but like I'm good. I don't crave it. I don't want it. It doesn't matter to me. And I've like expressed that to people, but they still come up and they're like, sorry if talking about this is not like, do you know of a good whiskey? I'm like, yeah, this is a good one. This is a good one. It's like, you can still talk to me about it. If you talk to me about whiskey, I'm not going to run to like my neighbor's house and break in and steal their liquor. Holy shit. I won't go to the store and drown myself like the guy in that the Constantine or whatever like that. I'm very fortunate that way. I don't have that sort of issue. But people are so cautious. It's like, guys, it's okay. Like, I also knew how to not drink while I was drinking. Like I could also like go time without drinking then too. It's fine. I'm going to make it.
Thank you, Your Honor. So I just want to clarify the issue really, if we boil it down, is if these 23 media entities have met their burden to be a limited purpose party in this case. And I think another part of that is what that means. What did this bitch just say? I think these have met their burden. If we boil it. So I just want to clarify the issue.
What are you boiling? Chicken? God, I bet she can't cook. You know she can't cook.
Issue really, if we boil it down, is if these 23 media entities have met their burden to be a limited purpose party in this case. And I think another part of that is what that means. And really that is what we are primarily concerned with. What does that mean? What does that enable them to do?
Guys, you can't see it because I got it really small, but I have really good vision. Those pinstripes aren't actually pinstripes. Those are Aramaic script lines going up her arms, up and down her back, and front, and skirt. She's in on it.
Jurisdiction is this court exercising over them as a result of them being a limited purpose party, because I do believe that is another aspect of asking to intervene in a case.
She has Aramaic script. This jacket has bricks like the Wailing Wall. And it has Muslims on top that throw rocks at the people praying at my feet. So come on. We're different.
Damn. Candace having a rough go this year. In deep waters with President Macaroni too, claiming his old hag is really a dude. Sheesh.
This nickel sounds like a Paris Island drill instructor. What with all the creases and ironing?
This is boxing. Baitu.
Beta. A Paris Island drill instructor. I'll teach you how to drill. Megan didn't zoom in. It's not pinstripes. It's Aramaic text. Stop it. God, Megan, stop. Didn't you get your orders? Fucking. I'll DM you, Megan. God damn it. Stop doxing us.
I do think that Rule 24 does not apply here. I think that's what we...
Rosalind Duke, your grandmother had a bedspread like your jacket. I love that bedspread. I know. Where do you think I made the jacket from? I got it from your grandmother's leather bedspread. Also, into some stuff. I'm just saying, she was into some stuff.
Learn from the Supreme Court. They don't want individuals using Rule 24 of the Rules of Civil Procedure because it's too expansive. It's about broad entry into a case for many purposes.
This broad is expansive. The broad at her desk is expansive.
In the instances where our courts have allowed intervention into civil cases, and I want to be very clear here, the case law is in the civil arena. There are very few instances where we're dealing with this in a criminal case on appeal. So we're a little bit in the dark, and we're asking this court to kind of wade through and make a decision that potentially hasn't been made before. But I would ask the court to be very clear, no matter what it does, on what the media can and can't do in this case. And it sounds to me like the media has somewhat conceded that their role in this case is under Rule 4-202.04, and their role is to have a voice regarding closure, which has already happened today, and will.
Fletcher Boy says, I didn't think we used the word broad anymore. Well, if they would narrow out, I would stop, but they won't. They just keep inflating.
Surely happen again. We have no objection to that. And to be clear, we're not objecting to the court's order about notice. We will provide notice. We will follow the court's order. We have no problem with it. But we do want this court to make the procedure very crystal clear. We want time frames. We want orders saying this is when you need to respond, so that we don't end up with filings like we did this week, very shortly before the hearing, that we have to rush to respond to. We're all attorneys. We all know that these things happen from time to time, and we're not unreasonable folks. If they reach out to us, we will grant reasonable requests for extension.
What attorney do you know that's not
so
unreasonable?
Everyone is aware, but there was no communication. So I want it very, very clear what they can and can't do. It's less about semantics. This isn't about semantics.
You may want it clear, but it's going to be a little milky. I mean, just warning you. She's a lesbian. She doesn't know these things.
It's about substance.
Is she actually a lesbian?
What are
Is
they
that a real
allowed
thing?
to do? If this court wants to call them a limited purpose party, that has to be, well, it's so you can exercise your rights under 4-202.04. And in doing so, this is what you need to do. That's what we're asking the court to do. And I also have some practical concerns that maybe need to be addressed with the court's clerk. For example, are we adding all 23 media entities to the court docket? Will they have access to all of the filings? I have had instances in the past where, unfortunately, parties have been added to a case and still receive documents that are intended to be private or non-public. I'm very concerned about that. So I think it would be appropriate, if they are going to be added to the docket, that it.
Anyway, Passable says, if you need your chat room to live stream, you shouldn't be here. Yeah, if you guys need your chat room to live stream, you shouldn't be here. What are you talking about? Locals. What is happening over there? Demon Slayer says, tons of respect, but this isn't you. Oh, it's someone else. Got it. Hey, brother, just relax. It's all right. This is fine. You're going to be okay.
Be reasonable, perhaps just the two entities that are requesting, the two conglomerate entities that are requesting, and that there be an order from the court saying if they receive something that they shouldn't have, they notify us in the court immediately and they delete it. They don't review it. At a minimum, I think that's necessary.
We are blessed to have you.
But I also think it would be reasonable for this court to not to put them on the docket for that very same reason. So we don't think that they should have permanent status in this case. We don't dispute that they are going to be here. They're already here, as we well know. But we do think how that happens is important, and that this court should exercise its authority to make very clear what everyone's roles are here. And as I believe they put in their briefing, that they are neutral observers. Neutral observers. We don't want the chaos that is out in the media.
Unsenstein, yeah, I would have loved to. Demon Slayer, I love you too, man. Just
for reals, yo, grab some 24 or 48 Melon juice. Vaping this heavily is neurotic.
Oopsie, somebody made cumsies on my chesticles.
Clean it up, Beta.
God damn it. Ah! No, I like, the thing is, I like sucking a lot. Like, I like sucking and blowing a whole bunch. Like, it's, puns and jokes aside, like, that's actually, I don't really feel I know the nicotine has a mild stimulant effect, and it helps keep me awake and stuff if I'm like driving or whatever. So that's nice. But like I like the taste and the cool feeling in my mouth. It makes me happy. Nothing about that sentence was good. Nothing about that sentence was good. Here we go. Unsenstein says, I watched this whole thing live already, wishing Nick was streaming it. My kids did a choir concert today, which was awesome. They always have around Christmas time, so it was fun to go get to watch them, sing with the choir and do that stuff. And I think that's when that was a little bit after when this was going on. But yeah, I mean, when I found out this was going on, my schedule just didn't allow me to. I wasn't home at the time. I wasn't able to get on a live stream to do it. So I'm glad to be able to cover it though now, which is cool. And when the trial comes around, next year, hopefully the things will be opened up and ready to go, so that we can cover this trial. I really want to cover the Courtney Clenny trial. I really want to cover this trial. Those are two that I'm wanting to cover live, specifically in the first quarter of next year. And so hoping that is a thing we get to do. That would be our first and second quarter of next year. Hoping that we get to do that. That'll be a lot of fun. I want to get back to streaming some trials. But like these hearings that kind of crop up randomly, I mean, I don't have a good way to keep track of all the different shit that might happen with these little hearings. If you know of a hearing coming up in a case or something, or a trial you want me to watch, you got to let me know what it is, because I am not out there following all the stuff you guys are. But that doesn't mean I don't want to, or like, wouldn't consider doing it. So let me know if you know ahead of time. Happy to do it if I can. But, my kids obviously take priority over pretty much everything.
In this courtroom.
Who else am I going to get drugs from?
So whatever this court can do to prevent that is what we're asking. Does the court have any questions for me?
No, thank you.
Thank you.
Yeah, Flightless 7. Flightless 7 just said it. Oh my God, all the school concerts right now. If you have one kid, you're busy at this time of year. When you have 5 and they're in like different activities, everybody's like, you know what? They pick like 1 week in December and they all confer in a giant cabal. And they get together and they just pick 1 week and they do like everything back to back. You're like, kill me. Can't you do one event where you mix all these things up? Like do basketball and choir at the same time. That'd be funny. Something for you guys to ponder a little bit, right? Something for you guys to ponder, because I've been thinking about this. Because they're talking about like how going into the midterms is going to be like a disaster for the Republicans, et cetera. And it very well may be. And we may see a Democratic shift in power, akin to 2010 with the Tea Party movement, but in reverse. And so like, I don't know, with the estrogen part, whatever the Democrat thing is going to be, they're predicting this. But I just want to say, like, Rush and Glenn Beck both talked about this. I think Crowder's talked about it too. But like, when Republicans assume power, it's like the Republican Party or the conservative movement has no idea what to do, so they immediately turn around and fucking eat each other. And if you want to know why we're going to lose the if you want to know why Republicans are likely to lose the midterms and lose control of the legislative body of this country, like a big part of it is going to be all of the schisms going on in the conservative movement. Candace Owens, Tim Pool, Daily Wire and Crowder, like all of these little schisms that have happened over the past couple of years are just building and building and building. While the Republicans have had this power, they get lost. Democrats don't get as lost when they have power. They're focused. They have a long-term plan. Republicans are like, we just kind of don't want what they have. And it's always been a problem, like a policy problem for the right. is conservatism and traditionalism or whatever. Those things focus on what we have and just preserving it. But that's not a plan of what to
Any
do.
chance you could collab with Mr. Rivers? That would be epic.
I'd talk to him for sure. I don't know. But if he'd want to, you know, I could make it worth his while with, like, I could give him a back rub or something. But now we have Marjorie Taylor Greene splitting with Donald Trump. Like, we have all of these schisms, and it happens like this every time when the Republicans finally grasp power. You're like, yes, lower taxes. And they're like, nope, because everybody's individual interests start to separate the party out. And, you know, it's happening amongst the gab class, not the politicians as much, mostly the talkers. And it's wild to watch. And it's like, well, yeah, we're going to lose power because you guys can't stay united on anything. And everybody's like, now it's like they hate Tim Pool or they hate Candace Owens. And it's like no going between those two. There's a rift between Turning Point and Candace Owens. Nick Fuentes is in there. There's like all these different stuff. There's no bridge building going on. It's very much bridge burning. Hallucinosis says Candace Owens is a super retarded leftist BLM person. I think people forget that Candace Owens, her conservatism is relatively new. I mean, I don't know how old she is. She doesn't always look haggard or anything. So I don't know, like me, I'm like, holy fuck, you're old. But like, I think I'm older than Kim. I don't know. Maybe she's older than me. Doesn't matter. So like, I don't know how old she is, but on the relative timeline, you know, she seemed to be, she kind of eased her way into the conservative movement. And it's interesting how like the rise of Trump kind of mirrored Reagan in so many ways, but in different ways. And Reagan was a big tent Republican, brought a lot of Democrats under the big tent and said, no, these are Republican principles too, the middle class, the working man, all this stuff, blah, 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 blah. And similar things with Trump. And what you get, though, is that once you have power, you realize that you didn't actually agree on stuff. You didn't actually agree on stuff. Populism and conservatism don't actually match up in lockstep as well as people may assume for a minute. So I'm really curious how it's going to pan out, but I'm also curious why they haven't figured this out yet.
All right, counsel.
She's 36.
Thank you, Your Honor.
Barely
Just
a
very
baby.
briefly, I'm not sure what neutral observer is supposed to mean.
Anyone's
we have interests in the case. We are here to advocate.
This guy's like, did someone say baby? I want to eat one of those. Holy shit. Look at this. Why are you wearing a fleece vest over a tie? Does it say Columbia or North Face on it? Fuck's sake.
For openness and against closure. And so I don't think that's what counsel meant to imply, but that's the whole reason we're here, is that no one else represents our interests. That is straight down the middle of what the intervention rule requires. Just a couple clarifications. Counsel said we haven't cited any criminal cases where...
Oh, duck fat. So when it gets really... So what you're hearing is occasionally my... when it gets really cold, my air conditioner will make that sort of high-pitched whining sound. But if I turn it off, I'm in an enclosed vault that's underground. So like the computer and the lights will heat up this room really, really bad. So, but when it's really cold outside, maybe it just has to do with bringing in such fucking cold air.
Where this has been allowed. That's not true. We cited the court to 8 different cases, all criminal cases in the state of Utah, where this is the procedure that judges routinely follow, including judges in this building. Counsel said that our role is strictly limited to advocating for what is under Rule 4202.04. I don't think she meant this, but as the court probably knows, that just deals with court records. We're also entitled under governing constitutional case law to advocate against the closure of proceedings. And that rule does not technically apply to proceedings, it just applies to records. So just to be clear, but I think we have been clear, and this is all, I mean, there wasn't a whole lot of daylight between what counsel was just suggesting our role should be and what we've asked for, you know, which is just if they file a motion that seeks to prevent, that wants to classify something as non-public, like they did last night with the motion to disqualify. They were able to at least provide that to us. It's not very hard to send an email. That's all that we've asked for in terms of the notice.
Peachy, I
and
will
then
drop
we have
my
the right
voice
to be
an
heard
octave to
on
help
those
you
issues. And so I didn't really hear from counsel any reason why we should not be granted limited party status in this case, other than just some sort of, confusion on their part as to what that would actually look like.
Candace is
I don't know
batshit
how the
crazy,
court-
always has been.
Bing, bing, bing. Looking good, like Bono Ringo.
Thank you, Tartikex. I really appreciate that. By the way, if any of you are tired, we can move into ASMR, help you go to sleep, boring law voice. Settle in, give your vocal cords a recliner, and let them relax.
Deals with parties on the docket. I assume you guys can sort that out. Typically, when we intervene on behalf of the news media in cases, they are listed because they are limited purpose parties. But the court can, if it doesn't want to hear from us on a particular issue, it can certainly say that. I mean, we don't have any interest in weighing in on aspects of the case that don't have anything to do with the public's right to know. And so I didn't really hear an argument against what it is that we are asking to do. Just one last point on, well, two things. One is that
he just pulled the Stefan Molyneux. Not an argument. Not an argument.
Counsel's chastising us for filing something late. I mean, this was a stipulated motion that got us here today. We weren't asked to weigh in on it. It was submitted to Your Honor with an order, which they just assumed you would sign because it was stipulated. It was only because this court said, no, I'm not going to do that. I want to actually hear from the parties that we weighed in. So this was not your typical deadline where we were invited to weigh in and just didn't. Last thing is, in terms of docket access, Mr. Hunt and Mr. Judd and I are all officers of the court. If the court says you can have access to things that the parties are seeking to classify as non-public, but you can't share them with your clients until further notice from the court, that's fine. Some judges do handle it that way. Sometimes we just, if they don't concern closure, sometimes we don't weigh in at all. But, when they file things that they say we need to file this under seal and we're not allowed to see it, then the briefing for you is not super helpful, And so typically the way this happens is we are allowed attorney's eyes only access to, documents just like the state.
Melvin Silver, thank you for the advice. Giving a nicotine patch a try. It's a better delivery system. It's not about the nicotine, really. It's if this is a nicotine-free, I think they make those nicotine-free vapes or whatever. It'd probably be similar. I like the cold feeling of like the mint in my mouth, and I just like I don't know, something about the act. I guess like I probably should be sniffing it in my nose, right? Like it should be. Have you tried Zyn pouches? No. Achilles, don't you dare pause at me. Don't you do that. It's about having something other than your dick to play with. We're not going to talk, go watch Theo Vaughn explain cocaine to someone. Just sit there holding your wiener. We're not going to talk about it, okay?
And the defendants would be. Their counsel can see things that are non-public, and we don't share them with our clients unless the court orders otherwise.
I'm wrong on Tyler Robinson? Wait. Does he have a jaw that I don't see? What am I missing? I might snuff. I don't think so. I don't think so. No thanks.
And typically, if the court decides, no, this really doesn't need to be filed under seal, then we can provide it to our clients at that time. But this idea that our clients are somehow going to get access to things that are non-public, that's just not the way this typically works. If they're not public on the docket, if they're public on the docket, anyone can get them. And if they're not public on the docket, then our clients can't get them. And if there's a procedure where we can see them so that we can give the court the benefit of briefing substantively as to what it is, then we keep them attorney's eyes only until the court orders otherwise. And that's just typically the way this works. So, thank you.
Anything further?
Your Honor, I'm not going to belabor what's already in the briefing. I do think it's concerning to just cite to a bunch of trial court cases without providing any pleadings or context.
Look at that Christmas roast.
I dare you to really sniff it. What's the price?
No, other than coughing a whole lot, that would be it. Dude, I snorted whiskey. I snorted bourbon. Okay, like we don't need to revisit those days. GB8641. Have a good night. Have a good night.
For what occurred in those cases, I can't argue against what happened in other cases.
Don't snort
This
bourbon.
is our case. Our case is different. This court has already acknowledged it. There are many interests. We have concerns about leaks, information getting out that shouldn't be out. I think those are valid. And our concern is access. I'm not impugning the integrity of these gentlemen. I'm sure they would act as officers of the court. But the more this court...
Ascili, snorting bourbon, no, I don't think it gets you drunk faster because like the capillaries in your nose aren't good at your nose is, the way your nose works is it's there to actually keep shit like that out. And so like when you get liquid in your nose, it doesn't like absorb in your nose very well. I was jokingly snorting bourbon to take care of some other stuff that was in there. Cause sometimes like you would like you shoot some saline or something in there. Cause you don't want remnants. It was a joke. I tried it one time. It was not pleasant. It was not pleasant.
Controls the information that ultimately it determines to be private, the more able we are to identify if there are leaks, if there's information that's getting out that shouldn't be, and
Do you
who did
remember
it.
when people were like putting vodka in their eyes?
So we
to get
are
drunk? Fuck
objecting
that.
to
God,
providing
that would
the
hurt.
media our pleadings in advance, even just to their counsel. We don't think that's appropriate. I don't see any authority for that. We're asking the court not to consider that. And we're concerned about opening the door to multiple other entities just filing in on this case, getting involved in the proceedings. We don't know exactly what media means either. So our position is and remains, they can file what this court has authorized to file in the manner this court authorizes to file it and be heard in the manner this court indicates. We understand they're entitled to closure hearings, and I did make a mistake. We agree that they have standing to object to closure as well. So they should be able to file those things, but we do not agree that that requires status in our case. So does the court have any questions?
No, thank you.
Thank you.
All right. I appreciate the argument from all parties throughout this day. I wish to commend the preparation and the quality of the arguments, as well as the civility that is sometimes overlooked, but I wish to recognize that and appreciate counsel's demeanor and their arguments today.
This judge has
I
middle-aged
previously
mom vibes.
stated when we began that I would be issuing rulings on the first issue.
I just
and when I
Her
began,
hair looks like Carl's mom's wood panel basement.
He's like, not everybody appreciates civility, but I really do. Calm down, Judge. It's weird. Stop it. Like, I really want to acknowledge that while you guys were arguing, you didn't call each other fucking faggot, like a whole bunch. Like, you didn't do that. So it's really nice of you guys.
I initially said October 14th. It's actually the October 24th audio recording of the closed hearing.
That is a
as well
soft-ass
as the
voice.
October 24th transcript of that hearing. And so I wanted to create, just make that small correction. But given the in-depth
Where's
and
Borowski
necessary
for every trial?
Arguments made in the closed hearing, I wish to take the time to issue a ruling that will say what will be disclosed and what will be kept private, because this court has a duty to do so. And I would rather do it right and take more time than to be rash and miss the mark. I need to be narrow in my approach, and it is an important issue, and so I plan to do that. In regards to the motion
We
for
gotta see
limited
something nice about the
intervention and
judge.
request for notice of motions to close,
He's
seal,
got
and
a nice
classify,
distribution of
I also
like,
wish to craft
silver
my
and
order
dark hair. I'll give him
in
that
such a
compliment.
way that is concise and addresses all the issues, the important issues brought up by all parties. And so I will be issuing that ruling at the same time. And so I will be issuing the ruling in regards to the state's motion to clarify court's pretrial and trial publicity order, and I am prepared to do so. Before I do that, what I want to do is, and counsel is being caught off guard because they were anticipating a ruling today, but what the court is intending to do is, and proposing to the parties, is issuing an oral ruling on WebEx that all parties can attend to. The reason why is I don't want to take a lot of time. These are important issues. I don't want to wait until January 16th. And I want to talk about potential dates. I don't imagine.
You know, this guy does some freak shit on the weekends. You know, this guy is just two midgets on top, like one standing on the other one's shoulders until they sit down. Then the real party begins under the robe.
It will take longer than 20 minutes for this court to issue ruling. And I want to get the parties' input in regards to their thoughts of the court issuing an oral ruling on WebEx. And so I'll open it up to the parties.
We don't have any objection to that, Your Honor.
Thank you.
Agreed.
We
The
have
gain
no
on his mic
objection
must
to
be
that,
redline.
Your Honor.
No way you could hear him in the gallery.
I know. It's like, just speak up. You're not baking in the library, dude. Look, Sunken Cathedral. I read it can work. It just didn't, and it hurt.
Yeah, same. All right. Well, next comes the trickier part when you have a room full of attorneys trying to find a date that we're all available. To our staff, what dates do we have available for a 30-minute block before the end of the year?
Judge, we do have December 29th at 10 o'clock.
How does that appear? How does that date work for?
This guy, this guy's like, the only dark spot is going to be on my chin and everything else is going to be lighter. I don't know about those glasses. I don't know about this guy. I don't trust this guy. Or this guy over here. I don't trust him at all.
For counsel.
That was 10 a.m. on the 29th?
Yes.
Your Honor, that works for Mr. Robinson. Thank you.
Same for us. All right. And to defense, in regards to Mr. Robinson, what is your position on, if it is on WebEx, he would be appearing by WebEx, or is there different thoughts?
He does look like Christopher Walls, whatever.
Your Honor, if we could just have audio only for Mr.
put it down.
Robinson to appear,
Pan out.
since we will not be present, I would rather not have him in
That was like when the Voyager probe got too close to Jupiter. Good Lord, it just took up the whole camera.
the courtroom without counsel present.
All right. Thank you. I appreciate that. So we will set the court's ruling on those.
Sunken Cathedral, I don't know how many days of trial they're planning for. Pre-trial is in spring of next year, which then they would set the trial date and the expected time of trial.
2 issues for December 29th at 10 a.m. And a note that it will be audio only for Mr. Robinson per defense's request.
Guys, Locals is on one tonight.
And
Locals
to the last issue
of course, a
well,
wonderful
before I issue
membership
my ruling,
option. Put your member in your
I
Locals.
anticipate, in counsel, are we still on the same page in regards to our January 16th hearing? Are we planning for that?
Your Honor, we are.
The sad truth of how big she is she's holding an iPad right now. It just looks like a phone.
We believe that most likely what we would anticipate doing is on January 16th, arguing our motion to disqualify the county attorney's office, which was just filed. That should give them enough time to respond to that. And also possibly, we anticipate filing our own motion about the pretrial publicity order that has a little bit different take on it. That should be filed in plenty of time for us to argue that on the 16th as well.
This is really like they're scheduling, and that's boring. Hrunting, I don't know what hrunting is. Says, is locals still just a wall of memes? Sometimes it's erudite discussions about Brazilians, blondes, and redheads, and sometimes it's memes. But it's whatever you want it to be. That's the best part of locals, is because you have a free chat that is pretty much uncensored, and you have the ability to post pictures and memes and GIFs or GIFs in the chat. Like you can kind of make it
Terms of service, hog teats.
Hog teats. You can make it whatever you want. So, that's up to you guys. It's a community for y'all to hang around.
Well, I think we have set aside the 30th.
Dicks, vaginas, and buttholes are not allowed on locals. Those are specifically against the rules. I haven't read the rules lately. Last I checked, they allowed nipples. There are not nipples going on, which is, I think that's generally for the better. But look, if you go in a chat room and you're like, hey guys, look at all my naked pictures, like fucking weird. you like, hopefully the community shuns you for that or praises you. Maybe your pictures are good. I don't know.
And that might be the one we want to save to argue our anticipated motion that's coming about keeping cameras out of the courtroom. And we will, I imagine the media will, depending on the...
Back when I had a Discord, there was one guy, he would just endlessly post anime porn, just constantly. So he had to like put up a room where he could go and just post anime porn all day. It's like, okay, that way no one had to like encounter it unless they wanted it. But really didn't talk much. It was just that. It's like, I mean, I guess that's what you want to do. I also no longer have a Discord. Rosalind says no naked pictures. I didn't say that. I just said it might be against the rules. These are the best shades for my face. Well, thank you. I like them. They're women's shades. Makes sense.
Court's ruling today will want to weigh in on that one as well, and that would give them enough time as well. So that would be January 30th.
All right, and before I go to the other parties,
yeah, the Discord was
the
a
January
mess,
30th date, there was some complications, and so we have to find another date.
Okay.
And
I mean, Discord is for furries and faggots. Like that, it's never not been, and it's only a matter of time.
Okay. And so I just wanted to let all parties know before we lock in our schedules, what dates do we have available for a 4-hour setting?
It's okay. My problem.
And Council, I appreciate you giving me that roadmap that helps plan. So
Blazer says,
it allows
Nick,
the other
lock in.
parties
Is this
to
normal?
take
Yeah,
in
I mean-
consideration dates.
So right now they're just trying to schedule things out. But as far as the requests in this case, like the request for no media coverage, it was normal. It unlikely to succeed so long as everybody kind of behaves. They tried to latch on to some accidents by the press at the beginning of the day today, and it didn't end up working, right? Like it didn't end up working for them. The judge basically said, look, if we have screw-ups like that, though, I will have to consider, taking away the media access. But generally speaking, this is going to be open to the public. It's a public trial and a massive public event that was national news. Keeping it behind closed doors would be crazy. It'd be crazy. This is state court that allows cameras. It's going to happen. Now, if it were in federal court, of course, federal court doesn't allow any cameras at all, which I think is also wrong. So who knows? But like all of the requests here are basically normal as far as like scheduling the preliminary hearing and scheduling the next stuff. And they're dealing with procedure at this point. We're ways away from trial itself.
Filings as well. So as staff is doing that, they are looking for hearing dates. And one of the complications is, as a judge, I have 1,409 cases as of last Friday. And so trying to find a spot is tricky. And I'm grateful for my staff who work so hard to manage that calendar. So that is part of the reason for the delay. And we're trying to find a date because this is an important case, as is all of those cases. They matter to me.
Your Honor, while we're waiting, can I, if I might just make one point that might make things smoother as we go forward with the sealed filings? Just to Ms. Nestor's point, Mr. Novak earlier mentioned something about a redacted motion to disqualify, and I don't know if that is something that they're planning to file, but I was just going to say sometimes, what we heard earlier about that particular incident is probably not something that we care that much about in terms of what they would redact. And so instead of opposing the motion to classify, if Your Honor, I don't know if this is the plan already in this case or whether that's what they were planning to do, but if they file a redacted version that,
is he most
just
likely
takes
to
out the stuff
take a
they
plea
care about
deal?
rather than closing the whole.
Well, I mean, I think they're going for the death penalty on this, and in the alternative, life in prison. Maybe they'll offer him a life in prison plea deal. Maybe. If he gets that, he may take it. Right now, their posture is like they're not going to be. They're going to act like they're going to trial because that's leverage. Cat 10 Barge who did the ASMR clip. Oh shit! Yeah, I remember that. That was wild.
Thing, then we don't have to say anything and probably avoids fighting over unsealing that document. So I just wanted to say that. I'm happy to confer with counsel if you'd rather us do that. If you don't want to do it by way of a court order, but
no, I appreciate that input. I'll hear from both parties, and then we'll get to the date.
Your Honor, I do anticipate going through and seeing what we can redact and working with the state on that as well and with media counsel. So.
All right.
And we agree that filing a redacted version is a good way to go. We can work together on that. As far as the January 16th hearing, the state will do everything it can to respond to these motions as timely as we can, as expeditiously as we can. I just want to note that January 16th hearing was set with the expectation, the previous expectation was that defense counsel was going to get us these motions before Thanksgiving. And we just got the motion to disqualify last night. So we'll do everything we can to respond to those as expeditiously as we can and hopefully keep that date, but I'm not guaranteeing that we'll make that date.
All right. I appreciate the heads up. Going to staff, what dates do we have available?
Oh my God, I hate this scheduling part.
February 3rd, morning or afternoon setting?
I actually can't.
Your plan? That works for Mr. Robinson, Your Honor.
What do you guys want to talk about when
you.
this is done?
And
It's about
morning
to
or
be done
afternoon setting?
in. Holy shit! There's
Either works for us, Your Honor.
fucking 19 minutes left.
As well as for the state, we're available on the 3rd.
The
Anytime.
afternoon would be better because it may be.
Hey, while
that it
this
reduces,
goes, I'm going to run to the bathroom real quick. I'll put this up here,
problem.
and I'll be right back.
All right.
I just got to
Well,
pee.
It's always nice
Nothing's
when all parties
happening.
agree.
Talk
So
amongst yourselves.
We have February 3rd.
I'll be right
at
back,
1
and then
p.m.
we've got other
It
stuff
is
to talk
anticipated
about.
to be in
I'm
person.
not quite ready to go to bed yet.
Ms.
I don't know about you
Nestor,
guys.
is Mr. Robinson planning on appearing?
Yes, Your Honor.
All right, thank you. All right, that concludes that particular issue about future dates, and I appreciate counsel working with me on that. We have December 29th at 10 a.m. for the court ruling on these two issues, and that will be via WebEx. And then February 3rd, January 16th, I believe that is at 1 o'clock. Is that correct? All right, that's in person as well with, I believe, defense has indicated Mr. Robinson will be present as well. And finally, February 3rd at 1 p.m. and also indicating that Mr. Robinson will be present. And in regards to the final issue, the ruling on the state's motion to clarify court's pretrial and trial publicity order, this is the order of the court. The court issued a protection order regarding pretrial and trial publicity in this case. The order prohibits attorneys who are associated with the prosecution and defense of this case from intentionally, knowingly, or recklessly permitting a witness, investigator, consultant, staff member, or other member of the prosecution or defense team to make extrajudicial statements, which, if made by the lawyer, would violate Rule 3.6. To that end, lawyers participating in an investigation or litigation of this case shall inform all witnesses, investigators, consultants, staff members, or other members of the prosecution or defense teams about the prohibitions contained in this order. The state moves to amend or clarify the court's use of the word witness as used in the publicity order because it is vague, ambiguous, or overbroad. The state asserts that there are over 3,000 lay witnesses of the alleged homicide. The state does not know if it must inform each potential witness or each potential and possible witness of the prohibitions in order, or whether the order applies only to witnesses who are members of the attorney's teams, such as investigators or experts. Due to the potential confusion, this court grants the state's motion and offers the following clarification. The word witness, as used in this order, applies to all witnesses who are part of the prosecution and defense teams. This includes any witness, including lay witnesses, whom the prosecution or defense has a good faith belief will be called to testify at a hearing or trial. The court also clarifies that the publicity order as written regulates the behavior of attorneys who are associated with the defense team or the Utah County Attorney's Office. It requires the attorneys to abide by Rule 3.6 and in order to deter non-attorneys from making prejudicial statements, requires the attorneys to inform witnesses about the prohibitions in the publicity order. Informing witnesses about the prohibitions in the publicity order is a necessary step. It is one moment as I regain my place as I read.
How'd you lose your place in your own document? Oh, wait, is that not, it's not his document?
Informing witnesses about the prohibitions in the publicity order is a necessary step toward not intentionally, knowingly, or recklessly permitting witnesses from making prejudicial statements. The publicity order does not regulate the behavior of any person who is not an attorney associated with this case. And this order will be signed today by myself and made public. Counsel, is there anything further that we need to address today?
Thanks, Your Honor. Yes, just the matter of having Mrs. Erica Kirk designated as the victim representative in this case. She has filed through her counsel a request to be designated as the victim representative. And,
okay, what's wrong with that?
We'd like the court to formally acknowledge that request.
Oh, I see.
And formally designate her as the victim.
Can she be the victim representative if she conspired with Candace Owens to do it?
Victim representative. And I guess along those lines, I wanted to make clear as well, I think this court stated earlier that there was an alleged victim in this case. And I know that there is case law talking about being careful about how we refer to victims and alleged victims. But in this case,
Fletcher Boy says, actual real law stuff. Brian Walsh offered no defense. Good, bad. It's a strategy, right? Like, one, we'll talk about it in a minute. Let's get through this. I can answer that question. Fletcher Boy, you don't have to pay. You can, but you don't have to pay me again. But just tag me and remind me to talk about the Brian Walsh no defense.
That case law makes clear that those cautions don't apply with the same degree, where it's clear that we have a victim who was killed in this case. We don't have an alleged victim. We have an alleged perpetrator, but we do know that we have a victim in this case.
Thank you, Mr. Ballard. I'll hear from the parties.
Your Honor, on behalf of Mr. Robinson, we certainly think it's appropriate for Ms.
So, the victim representative is someone who, in the absence of a victim, because they're dead, for example, represents the interests and rights of the victim, right? Like the victims have rights in criminal trials. They're limited, but someone has to be there to assert those rights. And in the case of a slain spouse, typically the victim representative would be the widow or widower, as it may be. If there isn't a widow or widower, you can assume a child, someone with consanguinity, effectively would be a logical connection. In the absence of that, you could have someone who's a very dear friend who's trusted. There's all sorts of ways to establish someone as a proper victim representative. It's not saying that they're the victim of the crime. I mean, Erica Kirk is presumably a victim, but not the victim of the crime. The victim of the crime would be Charlie Kirk. But the rights of the victim need to be represented by somebody. As SuTube says, what about his parents? Yeah, I mean, so if there are multiple proposed victims representatives, say there's a family with like a nasty feud amongst the siblings, maybe multiple people would sign up to assert the victim's rights, and then the court would decide who's going to represent the victim. Right. In this case, I doubt anybody is going against Erica Kirk as the victim representative. I mean, she's the spouse. Presumably their marriage was in like some level of positivity at the time of the assassination. And so, I mean, outside of something really compelling, asserting the rights of the victim is going to be tough. Because again, they're really, really limited. There's not much that a victim gets to do. They can object to some things. They get to object to a proposed plea deal, et cetera, stuff like that. They may be able to offer a victim statement. When there's a deceased person, kind of hard to have a victim impact statement from the victim. But family members of victims often give victim impact statements too. So, there's a lot there. This is not controversial at all. This is completely normal. This won't be as long as the Depp trial. Well, it kind of depends. There's a bunch of witnesses, but I wouldn't think it'd be a 7-week trial. Holly Movie Star says, follow 14-year-old Danica Troy trial, Pace, Florida, if it airs. Okay, when's that supposed to be?
Mrs. Kirk to be designated as the victim representative, if that is the desire of the state. Just so there can be no doubt that she's afforded all of the rights assured to her under our state statutes, and we have no objection to that.
Yeah, and objecting to that would be dumb.
Thank you to all parties. This court will recognize Ms. Erica Kirk as the designated victim representative in this case. Thank you. Counsel, I believe that concludes.
All right, there's a good pause frame for this because we have this chat here.
Been hearing quite a bit on lefty sites that Tyler is wearing a tranny color tie. Many are excited, thinking he is sending a message with it. Thoughts?
Also, tell Kurt Candace Louv's micropeens.
Louvs him. Not wise for someone accused to do something like that, because the implication that Charlie Kirk was anti-trans and therefore, you're pro-trans and then you're supporting the trans community, standing accused as his murderer. I mean, it just doesn't do you any help, but there's nothing particularly against it. And saying it's trans colors is, I mean, I guess I thought trans color was like on the LGBTQ flag. I thought it was like brown or something. Arian, I did not watch Lil Woody's testimony. I did not. Is it good? It's worth watching.
Concludes our matters for the day.
One more.
Or maybe
Madam
not.
Judge. I can take the podium, Judge?
Yes, Mr. Germander.
The purpose, I want to just give the court an update with respect to discovery. We've done that at previous
Thank you. I
hearings.
appreciate that.
The state has received approximately 13,900 files from law enforcement in this case. Approximately 300 of those we believe are duplicates. We have since provided to counsel, as of I believe this morning, 7,951 of those files. For the court's information, we had reached close to 100%.
Sue, I didn't change clothes. I just took off my jacket. I was getting a little warm.
Had been disseminated as of last week, but we received quite a large batch within the last few days. So we were working on that. We still have a full-time paralegal that's dedicated to reviewing that, organizing it, Bates stamping it, and sending it out to counsel. Of course, there are necessary redactions that are being made along the way. Our next real hearing in this case, second matter, our next real hearing in this case is not scheduled till January 16th. We understand the court's caseload. We understand the difficulty of finding dates for a preliminary hearing. And we would like to make a request that the court calendar a preliminary hearing in this case.
All right.
Would I ever cross streams with Fuentes? Like, would I be on a show with him? I mean, yeah, I guess. Someone asked him a long time ago. He's like, that guy's lame, which is funny. I don't know. I don't really have anything to debate Nick Fuentes on. He has some different, again, and this is the thing that I'm running into lately with people who want to debate. They have some views or perspectives that are different than me, I guess, but they're not things that are like critical differences that I want to debate them on. It's just difference of opinion or preference. And like, I have no problem with it, even if I disagree. Like, I don't think that their professed opinions are particularly harmful. Now, I'm not saying that Fuentes doesn't have potentially harmful opinions. I don't know them all. I don't really watch. I don't pay that much attention to him. But would I debate? I would debate anybody on anything, I guess. I like to have discussions more than debates, but I would. But if it's better if it's something that I care about. Like I really cared about Roe versus Wade being taken down, so I was happy to debate about that. I was happy to debate that fucking Duncan retard who came on my show about the Keffels thing because I care about that. But yeah, it all depends on the subject. Like I don't want to go debate him just to debate him. Like I don't want to be like, haha, you incel or whatever. Like that's silly. That's what Piers did and it was wrong. Oh yeah, we never got the Destiny debate. I get why you wouldn't want to debate him though. Well, I haven't reached out to him yet because I'm about to be traveling kind of extensively for a lot of December, and I don't know when to schedule it. But I'll debate Destiny anytime, anywhere, any subject. But I've debated Destiny before. I'd debate him again. I debated him on presidential immunity. Hey, how'd that one turn out? Was anybody keeping score on the presidential immunity debate? Pretty sure I got that one. Tamara Holloway says trans flag is powder blue, light pink, and white. Oh, okay. His tie was lavender and cum colored.
In regards to, and I appreciate the heads up and acknowledging the busy calendar of not only the court, but all of you. What?
You didn't want to debate, just a normal stream? I mean, I would, like, if Fuentes wanted to talk to, I don't know why he would want to talk to me. Like, I don't really travel in the same circles he does. He's much more up and engaged in political stuff. I have political opinions, but like they're just like my opinion, man, and they're informed by my understanding of law and my life experience, and that's fine. But I am not I wouldn't be like one of those people, like I can't stream with him. I don't see why we would be on the same stream, but I'm not opposed to it. But I'm also not like, oh, I really want to stream with him. I would interview him. I would do it the style of, direct examination, because I'm kind of curious more about like what makes Fuentes tick when he's left to kind of direct the interview, even though he's not asking the questions, and like kind of what I pick up on. I'd be interested in that, but I really don't. I don't know. Like, I don't have a strong desire to do it, but I would. I think it'd be an interesting show. But it's not like I'm like, God, I want to interview Nick Fuentes. Like, other people are interviewing him. If he wanted to be interviewed by me, I'd be happy to do so. But like, I don't want to impose on the guy. He's busy. How do you not get tired? It's narcolepsy makes you really tired during the day, but kind of flips the script when you should be tired. If I laid down right now, I'd go to sleep real fast. Real Patriot Party. We'll get to your Rumble rant in just a second because it's about that Brian Walsh thing.
First of all, how many days does the state anticipate, which helps us in our calendaring efforts?
Judge, given that it's a probable cause standard, and all the inferences go in favor of the state,
Fuentes is more of
the state
a
is asking for 3
populist
days. We believe that we can present the evidence required to meet that standard,
Nationalists have
and that
strong
would also
state
allow
power.
the defense to cross-examine witnesses.
I'm more libertarian than that.
And argue that
to
standard.
say the least.
Thank you, Mr. Gernander. Turning to defense, what are your thoughts?
Your Honor, we were not aware that he was going to make that request today. We do have one more member of our team that's not present that we would need to consult with. I don't know when he's talking about, but I don't see how we can set it until all the discovery has been received. And also, we do need to deal with the disqualification motion, just in case. So it doesn't seem like a good idea to set it before we have the disqualification hearing. We were only talking about a month from now.
Yeah, Kel AZ1 says, I've never seen you vape before. Well, I didn't for a long time. But while I was doing a bunch of drugs and I was drunk all the time, the people around me vaped. And so I, would do it a little more socially. Then kind of, I did it a lot more when I couldn't do other stuff. So, then I vape a little bit more now. I don't know. But the reason you didn't see me do it before was because up until late 2023, I almost, I very, very rarely would vape. Very rarely. And I mean, we're talking like once a month. Like really, really uncommon for me to do it. It just became more prevalent when other stuff wasn't available. And it's more like, again, it's a lot more about the occupying your hands and mouth. I want to do the occupying. Balance Elemental One says, would you debate Dean Withers or Parker? Who the fuck is Parker? Sure. On what? It's all about, like, if I'm going to debate someone, I prefer it to be on something I care about, and have knowledge of, but I debated that one Republican guy on COVID remember when the Republicans were locking people up and cheering people being locked up for COVID before they remembered they were Republicans? Like, gosh, it's this weird thing at the beginning of COVID where they're like, no, we need to lock people up and shoot them if they come out of their house. And I was never for that. So like I debated him there.
I think that should probably be resolved before we set any dates. But I am concerned about setting a date when we still don't have all the discovery materials. We have significant discovery materials that have not been received yet, that we know are out there and coming and important. And we have to
Rice,
have time to review it all and absorb it all. And I am going to be involved in another trial that is not over until the end of March. So that's going to take away my ability to work and process through discovery and communicate with our team. So it seems to me that with the understanding of what Mr. Gernander's trying to accomplish, that maybe we come to the hearing on the 16th with an idea about, we can have some conversations with Mr. McBride and also with the paralegal that's dealing with all the discovery and see realistically when we think we're actually going to have.
Parker is similar to Dean. They're both more left than Destiny. I mean, what are we going to debate? The glories of socialism? I mean, okay. But the answer is sure. But to my knowledge, none of these people have asked. You know, when I debated Destiny on, I debated other lawyers on his show for abortion, or Roe versus Wade, and then I debated him on presidential immunity. You know, Destiny was kind enough to reach out and say, "Hey, would you like to join this debate?" And so I was happy to do so. No one's reached out to me to do so. There's some reasons maybe, but like, that's fine. I'm not out there like running around trying to get in on debate streams. Even if they would, you know, they would probably drive some interest or whatever, but like, they're frustrating because online debates is just really, it's a race to saying faggot. Like, it's just a race until you do that. And I'm a little racist, so don't always like those races. But I don't mind. I don't mind doing it. I enjoy them too.
The vast majority of the discovery materials to us and how long it's going to take us to review it all. So maybe we could just come prepared in about a month to try to accomplish that.
Mr. Grunander.
Just 2 points, Judge. Sometimes I feel like we as practitioners sometimes lose sight of the purpose of a preliminary hearing. It is a probable cause determination. The primary purpose, according to case law, is to ferret out improvident
this guy looks like
prosecutions.
A ferret.
So again, it's a probable cause standard. We are working as hard as we can, being very diligent with respect to collecting and disseminating discovery. Rule 16, subsection 2, speaks to the timing of mandatory disclosures.
Who the fuck is Deb?
And it is it's a continuing duty. So as far as complete discovery being provided, in a case like this, complete discovery is going to be ongoing until probably trial. There are times when things...
Yeah, the state is going to have complete discovery literally the day of trial. I mean, come on.
Become available during trial that are discovered to opposing counsel. But it says here, the prosecutor's disclosures must be made as soon as practicable following the filing of an information, except that a prosecutor must disclose all evidence that the prosecutor relied upon to file the information within 5 days after the day on which the prosecutor receives a request for discovery from the defendant. That's been accomplished. It then says,
Jeremy
in every
Davis,
case, all material
trial
or information listed
next
under
year.
paragraph
Pre-trial is
A1
spring.
that is presently and reasonably available to the prosecutor must be disclosed before the preliminary hearing. So we are in the process of that, collecting it as quickly as possible, making any necessary redactions, and moving it to the defense as quickly as possible. But complete discovery is not required before a preliminary hearing. We have to provide it as quickly as possible. We have that duty, and we continue to do that. So we think we can schedule a preliminary hearing and work towards that. I'm aware of Ms. Nestor's schedule. I know she's going to be in trial, I think, in February and March. And I'm probably overestimating the availability of the court's calendar, but the hope would be sometime in April to schedule.
Is that when you shouldn't waive your right to a speedy trial? Well, I mean, waiving your right to a speedy trial, like asserting your right to a speedy trial has some advantages, but like in this case, like the longer they delay trial it allows more evidence to possibly come to light. It allows more time for mistakes. Like, this guy is facing a conviction. A speedy trial doesn't hold promise of exonerating him. Now, there are some cases where a speedy trial might be good. Like if a witness might not be available now, but would be available later, or if there's an issue with like, maybe you know about delays in testing or something, they're going to have trouble like building up their factual record, and you want to put pressure on the state, and they maybe don't have the ability to get to stuff. Maybe some evidence is harder to reach now, so you can assert your right to a speedy trial. But a speedy trial isn't as fast, as you might want it to be. And if you assert your right to a speedy trial, they're just going to work faster on your case, and they're going to be more pissed off. Some people do it because they want to get it out of the way. And sometimes, like, the longer a case goes on, stuff could develop in the record later that would not necessarily change whether or not you're convicted, but change how you're sentenced. The other thing you may need to manage, is relationships during a trial or during the pendency of an action. And if you think that there's a possibility that someone who's favorable to you now might flip later on, a speedy trial could be beneficial in that way. So there's a whole bunch of stuff.
Schedule a preliminary hearing.
All right.
I'll submit it, Judge.
Thank you.
Your Honor, can I just clarify one thing? I mean, the county attorney has made a decision.
Lawyer's daughter,
very
you like the
public
glasses?
decision
Thanks.
to announce their intent to seek death the day that there was an
Really appreciate
arrest,
that.
which means that that obligation to provide us with the probable cause for everything they relied upon to charge applies now to their intent to seek death. And we're nowhere near getting that material. So that was their decision to release that. Normally, that decision is not made until 30 days after a preliminary.
Aggravated murder. You have an aggravated murder. You have a murder that is in public, and it's done with reckless indifference to the lives of the people around them. It's done over political speech. It's a motivated killing with terroristic intent. And none of this even requires evidence. It's all discernible on the face of the public news reports. So you're sitting here saying that they have to develop this reason to seek the death penalty and provide it. They will. They'll provide it. But they, like, come on now. Let's not pretend that Utah is not, the wisdom of seeking the death penalty and the justification for seeking the death penalty under Utah law are different. And I mean, they're going to meet that burden really easily.
Hearing, they made it in advance, and now they've got an obligation to tell me their aggravation and what they've relied on to make this a death penalty case. And we have not received that. So I'm waiting, but I'm just laying that out there for now.
You're waiting, and so is the person waiting your tables because you have multiple.
Thank you. I appreciate the
Does anyone know how
arguments
much
from both
evidence the
sides.
teams have in this trial yet? No, and the state was saying, like, the discovery in this case is going to go all the way up to the trial, maybe even into the trial. And this is very common in criminal cases that go beyond anything minor. You know, the state's developing the evidentiary record. Sometimes the morning of a hearing, they'll be filing, and serving discovery upon the court and the other party. Like, it happens with frequency. I think that's prejudicial, and I think they abuse it many times. But like, it's just how it is. Like, just because I think it's prejudicial and abused doesn't mean they're going to stop. They've been getting away with it forever.
I do not find there is any prejudice in setting a date for a preliminary hearing. It is not set in stone.
Rachel,
And it
Hughes,
certainly
sorry to
can
hear
be
about your
moved. I
headache.
recognize that the parties have a lot of obligations, but I also recognize the importance of this case moving forward. And if nothing more than this is a goal for the preliminary hearing, if it needs to be changed, the court understands that. That is what happens a lot in the criminal calendars and criminal dockets. What is a date that we may have of?
Did y'all see that college football coach who just got fired and then arrested? Sherrod something? Because Black Man's Kryptonite showed up? Holly Movie Star says, like movie Jury Duty, will jury be put in a hotel? Very unlikely. They really don't do that much anymore. You know, they put them under a sequestration order and they're expected to follow the order. Sequestering them physically is a real, like, that was really popular in the movies, and it was popular throughout the 70s, 80s, and 90s. Now, even in a hotel, they're still going to have the ability to access the internet. So they'd be under the same, like, and people, you know, like, wouldn't know as simply. So they're going to just put them under the order the same way, because it's going to have the same effect. Because, like, they're going to go, like this Charlie Kirk case, what are they going to do? Go to the fucking Holiday Inn that they're sequestered into, sit down after a day of trial. They're going to turn on the TV, and it's going to be on NBC or whatever, or CNN, because they're all Democrats. It'll be on CNN or NBC, and they'll be talking about the trial, and then they're going to already be at risk of the order. So they're going to they're going to have a duty under the court to not seek out information about the trial. If they incidentally come across some, to ignore it, to avoid it. And if they come into more information than just like an incidental headline or something, they have a duty to tell the court about it so the court can make the proper determination if the juror should be disqualified at that point. And that's just how they do things now, because information is so easy to access. Plus, it's really, really burdensome to put someone in a hotel for multiple nights. You're taking them away from their family, their children, potentially their religious practices. You're restricting their movement. It's a mess. So they don't typically do that as often. They can, they just don't.
Available for a 3-day setting for a preliminary hearing.
The first week that we would have available is the week of May 18th. We do also have a week of some days in June we could accommodate. We do not have any in July. We have some in August.
All right, let's take a look. So council, well, what dates in June?
June starting on the 5th.
So this shit's in June, July, and August. This trial is not going to start until fall to winter of next year.
All right. Council, I'll turn to you. Again, this is a goal. This is not a date that if we can't meet, there's any prejudice that will be attached to a party. In regards to May 18th, how does that tentatively look for council?
May or June?
May 18th is the first date, I believe.
Oh.
It is very common for court calendars, especially on complex cases, to be pushed out like this. I mean, my case went pretty quickly, but mind you, I pled in April after being arrested the previous May. So it was almost 11 months to my plea deal. That wasn't trial. Like if we would have gone to trial, it could have been months and months later to start the trial. You know, like these things take a long time. So this is very common, very normal. Cherry Blossom saying midterms, October surprise, possibly. But honestly, if they're going to have some pretrial hearings in June, they may not even start this trial until first quarter of 27 is possible too. That wouldn't be unreasonable. And, you know, if they start to get to those midterms or whatever, very possible that either the state or the defendant would be motivated to move them past midterms to get rid of the political rhetoric and political taint that is possible. So, I mean, there's all sorts of stuff that can happen here. Plus, the midterms may make some people not really remember the details of this, not be as familiar with things, and less likely to have a prejudicial jury.
So 18th, 19th, and 21st, just to give you the full range.
The expert. That 9-hour
The state
Lego
can make those
stream
days work, Your Honor.
was a miscalculation on my part. I should have picked a smaller Lego set. Thanks, Rice.
Okay, perfect. Your Honor, we have availability the May 18th with the understanding and the appreciation that if it's not feasible for us to get done when we need to get done prior to that, we would ask to push it back. But we don't have conflicts at this time.
All right.
So May. And I want to be very clear when I say that was a miscalculation. Going on the Lego stream was not a miscalculation. Valhalla had been inviting me for a long time, and I wanted to make sure I was able to do it. And devote the time to it. It was just a miscalculation of picking such a big Lego set. I wasn't really thinking about how long those take to build because I don't build Legos that often.
Thank you. So May 18th, May 19th, and May 21st.
Rachel, don't worry. I will not become addicted to Lego.
It will be in person, and do we anticipate, if that date moves forward, Mr. Robinson being in attendance?
Absolutely.
All right. Thank you. I just want to put that on the record as well. All right, I don't want to be presumptive, but is there anything else?
Tiger Up is right. Only 446 likes from 845 people. 852 now. Oh, yeah, 852 now. Plus, we got people over on Rumble. Hit the like button. What is wrong with you people? Do you not like the stream? Are you not entertained? Hit the like button. Let's get it. Show me that you love me. Validate my feelings.
Counsel, thank you again for your hard work today.
Radius
and I
Fear
wish
says,
you
Nick,
all,
don't get
Mr.
addicted to
Robinson, a
nicotine.
good afternoon.
I'll be okay.
Court is in
Don't worry about
recess.
it.
Thank you.
But thank you. Thought I missed the Lego stream because I couldn't figure out my camera. I mean, that was another thing is I didn't know exactly what I wanted to do. Oh, you thought I missed it because I was an hour late to it. Yeah. It wasn't just figuring out my camera. It was finding all the stuff for my portable setup, which I haven't used in a long time. Okay, so they're done. Squirrel, your best friend, says Lego's expensive. Try a cheaper hobby like cocaine. Facts. Fucking facts. You'll like it once I finish this vape. This one's new, so we're at 4 out of 5 bars of juice left. This will last a while. Okay, so that was the Tyler Robinson hearing. Took a long time because we got sidetracked, but really pretty basic stuff. Media's requesting access to cameras for one thing, and to not have things filed under seal. Or if they are filed under seal, the media is asking to be recognized as a limited party for the purpose of receiving anything that's filed, even if it's sealed, for review. Now, this is all derived from the media's right of access, or the public right of access to trials, to public trials. And so things can be filed under seal, but if the government is allowed to file whatever they want under seal, you start to not be able to trust that the government is acting justicibly, right? And so there's a right of media access to review those things and to basically be a second, like a third, I guess, set of eyes that has an interest in preserving justice from the side of the citizens. Now, when you are granted this limited access or limited intervening access to have, a public review or a media review of the documents, you're still bound by court rules. And this is the purpose of them being a party that's included, is they can see these things, they can have, exercise sort of a review of the documents to make sure the government is being honest about what they say, but they're still gagged in the same way that the parties are gagged from releasing those sealed documents. The sealing of a file is a court order, and you can't break it without permission. If you do, there are serious sanctions that are available. But they have to balance that with the public's interest in fair trials, non-prejudicial trials for defendants. And so that's the media's role here. They're standing for us, so they say. Lacey Marie says, like yours, realize the footage. I think you mean release the footage. But that footage wasn't part of my trial. If it was part of my trial, I wouldn't have an option to seal it. Nothing in my criminal trial or my criminal case is sealed. Not a single document, no videos, no hearings, nothing is sealed at all. So you have access to everything that was used in court for my pled out conviction. If someone's telling you otherwise, you have to consider that they're lying to you and they asked you for money to do it. But hey. Let's see, what do we got? Lacey Maria, I wasn't criticizing your spelling. I was just saying I think that's what you mean, because I was trying to, in good faith, make sure I got it right. But yeah. I'm really like, I'm not hostile here. Sorry if I'm coming across that way. It's just late. But no, That's the thing about the body cam footage in my case is it was mistakenly labeled as received into evidence, so people believe that it is. That was acknowledged as a mistake by the court. The court corrected it. People are trying to overcome that correction, which doesn't make a ton of sense. And they're using the analogy of like sealed documents in a case, but those files aren't sealed. Those documents aren't sealed. They're not present. But yeah, I'm sorry if I came across like angry or hostile or anything. Please chalk it up to fatigue. I'm not mad about it. It's just being matter of fact. Okay, let's talk about Brian Walsh. No defense. Real Patriot Party says. So someone asked earlier. Who was it? Fletcher Boy says, Nick, actual real law stuff. Brian Walsh offered no defense, good or bad. It's a strategy. It's a strategy move. And it sometimes works, it sometimes doesn't. But the idea is if you offer no defense, you're effectively telling the jury, they didn't even make the case for a conviction. We don't even need to defend it. They said all that stuff, and none of that amounts to a conviction, and that's what they'll make for their closing statements. They'll come out and say, the state told us they were going to show you this and this and this and this. Did they? No. Fuck them. If my client is under no obligation to defend himself or provide anything, the state is under the obligation to prove beyond a reasonable doubt that my client is guilty. If the state didn't meet that burden, we don't even need to stand up. And that's the strategy that you're going for. Now, at least that's what you front, right? Like that's the front for the strategy. There are other reasons to offer no defense. For example, if the state missed some stuff because it was going to rely on the defense to introduce those evidence, the evidence or the concepts, and the defense sniffs that out, and they figure it out, and they go, oh, hey, wait a minute. They missed this issue, this issue, this issue. If they stand up and start trying to talk about those issues and bring them in, or they get someone on the stand, they might actually spill and open the door to things the prosecution missed. So if the prosecution missed a critical element of a criminal act, then what you want to do is not have an opportunity for them to explore that. The final thing with offering no defense is if there's no defense, there's no rebuttal. So if the state held back some things because they were going to offer it in rebuttal to a potential defense or whatever, well, maybe that was a bad move. And that's a strategic question for the state. And so if the state missed out on that, then you don't want to give them the opportunity to remedy that. So that's why you might offer no defense. And it can be a valid strategy. Without watching the prosecution's presentation in the Walsh trial, I don't know if it's good or bad. Real Patriot Party commenting on that says, my take on a question offering no defense relies mainly on the presumption of innocence, yes, and reasonable doubt standards, yes, while avoiding witness cross-examination and disqualification issues, legit. Right. Much more succinct and concise way to say what I just said. Good job. And they sent that in before, but I didn't plagiarize them. Real Patriots Party, I'll plagiarize you some other time. Aaron C. says the issue with not offering evidence in that specific case was the defense's opening statement. So there you go. That's what they're going for. V-Sync says, can't you find a law and crime stream to use instead of Court TV? I had one that was neutral. It was just some local TV station, but the audio was just fucking buns. It was so low. We needed to find one quickly, and so grabbed Court TV. Arian says, when Larry Tipton argued to be able to argue in closing arguments that there's no proof she didn't die of natural causes, I felt like he did such a good job. Yeah, I haven't followed it, but I'll take your word for it. Okay, so what do we got? We were going to talk about something else. Oh, I was going to talk about this Andy Signore stuff, Popcorn Planet. Do we want to do that? Let's see. You're surprised I don't have Charlie Chaplin on my wall? Why is that? I have to find the Popcorn Planet website. Oh, stop. Jesus. Where's their damn website? They have one. The AI sex abuse hoax recently? What is that? The defense specifically mentioned several things that only Brian Walsh could testify to. The judge was surprised that he wasn't testifying. Oh, yeah. So that's interesting. I didn't really, like I said, I didn't really, it's just Popcorn Planet. I didn't really follow that case. So I don't, I don't know what else there is. I swear, Popcorn Planet has a fucking website. I was there. Oh, here it is. It's their fourth wall shop. Why am I hating on you? Rampant racism and sexism, probably. Michael Thacker says, I have an honest question with you. Have you quit drinking? I don't keep up with everything, just wondering for your well-being. Yes. The last drink I had was April 15th of this year. It's coming up on 250 days. It was April 15th, and on April 18th, I was sentenced to my probation, in which I'm not allowed to have alcohol or other mood-altering substances. So, yeah, it wasn't voluntary, but it did happen. Let's see. What am I looking for here? Oh, we're just going to move this over. Let's pull this up. Let's look at this Popcorn Planet shit that's going on. So this is in regards to Blake Lively and Justin Baldoni. Michael says, good for you, sir. Keep up the good work. You'll find it sucks anyway. Wait, the drinking will suck or the not drinking will suck? I've been on both sides of that coin. Both sides of that coin. Let's see. So here's the Popcorn Planet website, and we're gonna go to the news feed here. So this is a big thing. And so Andy, a little backstory here. Andy Signor used to help produce some very, very popular and influential YouTube channels in entertainment. Millions and millions of subscribers. And then he went through a personal controversy. I don't want to get into the details, mostly because I don't really remember them. And I don't want to, there's no need to pick open old scabs or whatever. Andy went through some personal controversy in his life, and I know a little bit about that. This is years and years ago. I believe that I was the first channel to have Andy back on, and we did a live stream. It was my first time meeting him. I had heard about his controversy, but we did a live stream together. He was announcing that he was coming back, asking people for support, and full disclosure. And I have my opinions on reasons for this, but I thought he was a little bit too. I thought he oversold it a little bit on because he was he was driving Uber or Lyft or something to make ends meet. He really got crippled by what happened, and he was like, "Look, I just need you guys to give me money," and I was like, "Well, that's it's a little much." Is how I felt. That said, really glad to see Andy has bounced back. Very successful. Popcorn Planet is closing in on 1 million subscribers if it's not there. And he's done a really good job. He's good at doing this. He's good at building YouTube channels and getting attention. And now I'm sure he doesn't have to ask for any of that. But my first impression of him was like, I like this guy, but I think he's really kind of missing the mark on how he's coming back. And it would be a while before he came back in full force. But the other thing that I got from that interview was like, I like the guy. He's going through some tough stuff, and I think that's why he came across a little bit overzealous, in my opinion. And I think that was the thing. He came across that way, but he was going through it, man. And like, I had no hatred for him. I wanted him to succeed, and so that was my opinion of it. But then he kind of blew up during Johnny Depp and stuff like that. And now he's kind of got this like drama lawsuit Hollywood thing kind of locked down. He's really good at it. They get a lot of people. Chris V. Clemens says, that said, Nick really needs your money. And that's a good point. That's a good point. Here at Ricada Law, we love money. We love your money. So long as you have it to give, it is very much appreciated. One of the best ways to do that is Super Tips. It's pinned in both the Rumble chat and the YouTube chat. supertip.gg/RL. You can use AI voices or not. You don't have to use the voices to send in. It's effectively like a super chat or a Rumble rant. I pull them up on screen. The AI voice will read them, or I'll read them if they're just text. And it's kind of a different, fun way to participate in the show. If you're thinking about sending a super chat, consider doing it on Super Tip, please, because if you send $10 in a super chat, the most I'll get of that is $7, and it's possible I'll only get $5.10, and the rest will go to YouTube and Apple. If you send in a super tip for $10, I get $9 out of it, no matter where you send it from, how, whatever. They take 10%, like the good Jews they are. They take 10%, and that's it. And also, I get access to it right away, as opposed to, the YouTube income pops in on the 21st of the next month. So there's a big lag period. So that's very much appreciated. If you don't want to do that, but you still want to contribute to the show, another great way is through gifted memberships on YouTube. Very awesome. If you're not a member, what are you even doing with your life? Like, you should do that. I do members only content. We've been doing it at least one members only show per week on the weekends, Saturday or Sunday. But lately we've been doing 2 to 3 members only streams per week. And they're just mostly fun. Like, they're a little bit less law focused and more mockery and mirth focused. We do a lot of laughing and joking and making fun of Kurt from Uncivil Law, as well as other people. And there's a whole bunch more of that to come. So if you want to do that, becoming a member of the channel is a great way to do that. And finally, it's Christmas time. The season of giving is here. Gifting memberships to other people, giving your member to someone else is a great way to do that as well. And that way you don't have to come up with a chat, to say or whatever. And people get a month of membership and they get to join the live streams. And the more members in the live streams, the more fun they are. So that's that. I don't like doing the sales pitch on it, but I really appreciate all the support. Of course, you guys make this able to be done. You make it happen. You make it happen. And I appreciate literally every donation that comes in. Donation, purchase, whatever the fuck you want to call it. Doesn't really matter. Okay, that uncomfortable bit aside, I was never good at sales pitching and closing the deal, so to speak. Which is why I only have 5 kids and not 30. That's a joke. That's a joke. It must be freezing where I am. You live in the South. It's cold there. Yeah, I mean, it's cold. Today wasn't bad, but we had some negative temps the other day. It was fucking freezing. -5 and stuff. Hey, Natalie. Nice to see you. Hi. We're going to be down in your neck of the woods really soon. I don't know. I'll get you the details. We got to do like lunch or something. All right. So Popcorn Planet is covering Jason Baldoni versus Blake Lively. And they got a little deep. And Blake Lively pulled something here that can happen. Blake Lively subpoenaed Popcorn Planet to produce communications that they had with people associated with the case, because they believe that Popcorn Planet may have information that is relevant to her prosecution of this case or defense of the case. I can't remember. I really don't remember what side of this Blake Lively's on. Here's what I know from Jason Baldoni, or what I know of him. He played a really handsome guy in this show, Jane the Virgin, I think it was. And Lady Raggets watched Jane the Virgin. I watched it with her. It's got some funny moments in it, but it was kind of like a telenovela style show, but it was cheeky about it. It was enjoyable enough. But he was a handsome man. And then this Blake Lively thing comes out, and it turns out he's a giant fucking pussy. He's a giant fucking pussy. And it's like, oh, okay. Well, now I get it. He's like, he had all the right talking points, and it still didn't stop him from getting Me Too'd and all that stuff. But we're not going to get into the merits of the case here. Blake Lively looks at Andy Signor and goes, that guy has information that I want in his DMs. And she requested it. Now, Andy, through counsel, fought this and said, no, I'm like a journalist. There are journalistic shield laws. You can't get me to out my sources. My sources are confidential and they're protected. If you can't have a free press without protected sources, and that's true. When am I going to be back in Nashville? I don't know. I would love to go back. I love Nashville, and it turns out I have a bunch of friends who live in that area. So I really want to get down there again soon. But yeah, Baldoni's a little bitch. And that's probably because he's so damn pretty. So Blake Lively requests discovery from Popcorn Planet, or subpoenas Popcorn Planet, right? For these messages. Popcorn Planet fights back and says, no, these are protected. I'm a journalist and you can't do it. Popcorn Planet loses. They lose on this. And the judge says, you're not even a fucking journalist, bro. You ain't even a journalist, bro. And Andy Signor goes on Twitter and he makes a tweet about it. And he says, well, we don't even need to go to the tweet because it's we got a press release. Let's take a peek at this press release real quick. For immediate release, Florida judge rules against independent journalism for celebrity Blake Lively. That headline should tell you the kind of posture that Popcorn Planet is taking on this. They believe that this ruling is not correct. Let's see. In a ruling that has alarmed digital media experts and First Amendment advocates, a federal magistrate judge in the Middle District of Florida has denied journalist protections to Andy Signor, founder of the independent news network Popcorn Planet, solely because his reporting appears on YouTube rather than in traditional corporate media. And herein lies the problem. Herein lies the problem. Solely because his reporting appears on YouTube is not correct. That's not accurate to what's in the order. I think they're KP Cluckin', you don't ever stop. That's not what's in the order, and we're going to take a look at the order. But this is how it's being billed. It's being billed that because he's on YouTube, YouTubers can't be journalists. And that's not what the order says. I like Andy. I'm on Andy's side here, and I believe that Andy should have journalistic protections. But the order is going to highlight some problems. Now, Andy has stated, I believe, that those problems aren't an accurate depiction of what happened. And that'll make more sense when we start going through it. And that he provided everything that was requested, and that the deficiencies pointed out by the judge aren't legitimate. But I don't know. Like, I'm not there. I'm not involved in the case. But I'm on Andy's side on this. And I think it's a crime, not a real crime, but, you know, like in principle, it's a crime that it's so hard to exercise journalistic shield protections in Florida, at least, because that's what this is about. It's Florida law on this. And I think the Florida law has a chance of creating effectively a journalistic license. And I don't think that's what the First Amendment is for. And I don't think licenses to exercise your rights are appropriate. I think you have your right. A right is a right. A right is not subject to a license. Okay, so. So anyway, I wanted to say that because I'm on Andy's side. I like Andy, but I'm also on his side in principle. A big advocate of the free press and protecting sources and journalistic shields. I think they're critical. But I think the way he's talking about it is a little bit of an undersell. Now, again, to Andy's credit, I'm not involved in the case. I'm not representing him. I don't have any interest in any of that. And I don't know what all was sent. Actually, he's stated that he provided more. And I'm willing to accept that the judge got more and maybe even mischaracterized it a little bit. Absolutely. Judges do this. They do this all the time. It's not like this is unheard of. So with all that said, let's take a look at the order. Lacey says, this chat is lit. I love a nice troll and laugh, but this is hard to fucking listen to. Just disappointed. I mean, I'm a dumb bitch and I know drugs and drink is bad. Okay. I guess. All right, here we go. So here's the order. Under Rule 45D3, Federal Rules of Civil Procedure, Popcorn Planet, Inc. moves to quash a subpoena for documents served by Blake Lively, who responds in opposition. Because Popcorn Planet fails to establish that the privilege applies or otherwise waive that privilege and fails to demonstrate an undue burden, the amended motion to quash is denied. So that's them losing. That's losing. So this matter relates to Lively versus Wayfarer Studios. So Lively is the plaintiff, which is pending in the Southern District of New York. Lively sued in December 2024 and alleged that during production of the film It Ends With Us, she experienced sexual harassment and an organized campaign of retaliation led by her co-star, Justin Baldoni. She wanted to touch that Baldoni baloney. According to the complaint, Baldoni engaged crisis manager Melissa Nathan to help Baldoni get ahead of the narrative and mitigate bad press generated by Lively's complaints. Don't hire a fucking crisis manager unless they actually understand how to manage a modern Me Too social media crisis. And how you do it is to firmly, roundly, and backhandedly oppose that accusatory bitch, whoever that might be. This is Me Too, baby. You can't play soft. You can't be flapping a limp dick against a barn door. You need to bust the gates down. You need to call her a lying fucking bitch. That's what you need to do. You need to take the firmest position you can possibly muster, because that's what they're doing. That's what they're doing to you. And there is no quarter. There is no mercy for you. They don't get it back. You can't be like, oh no, I love women. Our conversations were lies. She is lying. And if they're not lying, you're gonna fucking lose. And that's the way it's gonna go. But Justin Baldoni came out like a little pussy. And he's like, oh, no. I totally love women. He gave Blake Lively attention and control, which this Me Too shit is always about those two things, attention and control. They're going to use some situation with some partial truth and then manufacture out of it something that is beyond what was happening for the purposes of gaining attention and control. Remember, this is Hollywood, baby. Attention and control is money. Money, and not a little bit. Millions and millions of dollars, incalculable amounts going forward. That's why Me Too was so successful. That's why everybody humbled themselves and hopped on the fucking bus. But those guys on the bus got Me Too'd too. And none of them learned their fucking lesson. At this point, if you're getting Me Too'd and you're coming out and being like, no, go away. You don't deserve to rejoin the ranks of men or lesbians or whoever's getting Me Too'd. Doesn't matter. You don't deserve to stand up if you're not going to fucking stand up. Stand up, leverage your audience, and go after the fucking person who's trying to ruin your life. Full-throated. So the strategy allegedly included third-party advocates willing to provide a potential quote or engage with reporters on behalf of Baldoni and others, and the seeding of content on traditional and social media platforms. And this is where they're going to bring in Popcorn Planet. They're going to say that Popcorn Planet was all too willing, for whatever purpose, to provide a quote, get engaged with reporters, increase their presence, right? Because it's all about clout, is what they're saying. In an amended pleading, Lively alleges that this campaign continued after the filing of her complaint. According to Lively, that's what it says. The filing of her complaint. According to Lively, defendants directly engaged with media platforms to overwhelm and confuse the public's understanding of Miss Lively's allegations and to drive negative sentiment against Miss Lively and anyone who supports her or speaks out against Mr. Baldoni. Now, the big fucking miss here is engaging with the media to do this. This is why crisis managers who don't understand the situation may not be the best choice. Because what you need to do is independently come out full throttle, not reaching out to an outlet and a trusted source. Like, you can talk to a trusted source or whatever, I guess. But if you reach out like a spider and try to control and manipulate the narrative, that shit will come out. They're going to come out. I don't know how the Me Too movement has wielded so much undue power, and they've done it so well, and it always comes out when someone does something like this. If they're in cahoots. They're going to accuse you of being in cahoots even when you aren't. But here's the trick. Here's the social media trick, and I'll give this advice out for free, okay? You don't need to be in cahoots with anybody because social media is so big. There's someone who supports you. There's someone out there who supports like stepping on babies. Don't worry. Someone will support you against the Me Too movement. The moment the story comes out, there's people who are immediately skeptical of these whiny bitches and what's going on with them and what has been demonstrably going on for a fucking decade. They will support you. You don't need to involve yourself and try and be this, the web weaver. It's not your job. You come out, deny what they accuse you of because it's fucking false, and don't capitulate on the small things. Don't apologize. Don't do an interview. Don't offer answers to a list of questions because they're not under any obligation to publish all of the questions or all of the answers. They'll pick and choose. Don't do these things. Don't give them the tools. You just say, anytime you're asked, she's lying, we'll have to prove it out in the appropriate time. And that's what you do. And you do it hard. Vehemently defend yourself because they're vehemently attacking your life. Lively further alleges that this campaign involves statements by the defendant's lawyer, Brian Friedman, quote, who regularly issues inflammatory content to media outlets, and who says, quote, anything, whether true or false, that will harm Miss Lively's credibility and intimidate others from speaking. Lively alleges that Mr. Friedman's statements were published with actual malice because the defendants know that the core narrative advanced by Mr. Friedman, that Miss Lively fabricated made-up sexual harassment claims to seize control of the film, is false. Is it false? That's what happened. She seized control of the film. Increasingly, Baldoni is just giving her control of the film. And everybody's scared of Blake Lively is giving her control of the film. You know why they're scared of Blake Lively? She has a huge social media presence. She has a large audience. Isn't she married to Ryan Reynolds? Right? And that is that? She's married to Ryan Reynolds. So we've got and go back in time, not to now, because a bunch of stuff has happened. But if you go back in time, she's married to him. Ryan Reynolds is very popular. They have a lot of clout in Hollywood. They have a lot of money in Hollywood and elsewhere. These people are armed and they're hungry for more. She got that power. She got the clout. She got the attention. And Baldoni says she made up this shit. Okay. So stick with that. The defendants allegedly seeded social media content with content creators. So if you're sending out pressers to YouTubers, be careful. On online chat sites like Reddit, they're only sending it to gay people, I guess, and into publications with small audiences and lax editorial standards, the team would then amplify that content by sharing them. Okay, so this is what is going on. Here's where we've got some, let's see. Here's where we're at Andy Signor. Andy Signor is the founder and CEO of Popcorn Planet, which he describes as a publicly accessible news and commentary channel with nearly 1 million subscribers and a large daily viewership, hosted on Popcorn Planet's designated YouTube channel. Signor describes himself as Popcorn Planet's main host, investigative reporter, and paid employee. Signor claims extensive experience in journalism and entertainment news reporting. So these are all from Document 10, which I think is his affidavit. On July 1st, 2025, Lively subpoenaed Popcorn Planet for 7 categories of information related to the underlying action. Subpoena called for a response by July 23rd. Here's your first problem. All right. On July 25th, Signor moved to quash the subpoena, which he followed with an amended motion to quash on July 29th. That's 2 days after the response. In the amended motion to quash, Popcorn Planet argues that the subpoena seeks material covered by the journalist's privilege. Lively cannot overcome the privilege, and the subpoena imposes an undue burden because Lively could obtain the documents from the defendants. Lively responds that the subpoena does not seek privileged material, that even if it does, Lively can overcome the privilege, and the subpoena imposes no undue burden. We're not going to go through this whole document. I just want to get into the parts. So the first thing you got here is 2 days. They motioned to quash 2 days after the response is due. Rule 45D3A, Federal Rules of Civil Procedure, requires quashing or modifying a subpoena on timely motion if the subpoena requires disclosure of privileged or other protected matter, if no exception or waiver applies. Under Rule 45E2, a person withholding subpoenaed information under a claim of privilege must 1. Expressly make the claim, and 2. Describe the nature of the withheld documents, communications, or tangible things in a manner that, without revealing information itself, privileged or protected, will enable the parties to assess the claim. So this is called a privilege log. All right. A privilege log is a log of communications that don't reveal the communications but describe them. A conversation with a journalist about blah, blah, blah. about these things, and you describe it in general terms, and then they can determine if they want to challenge that privilege, and then the judge can review the privileged material and determine if it falls under the privilege or without of it. But you have to make this privilege log, and that log has to be detailed. Attorneys deal with this when the attorney is brought in as a witness, and then attorney records have to be subpoenaed. Some of those are protected by attorney-client privilege, but not everything you say is protected by privilege to an attorney, and so even less so to the press. So here we go. The party invoking a privilege bears the burden of proving it. A blanket assertion of privilege is insufficient. They must establish a privilege for each document withheld. Now, does that mean every single text message? Yes. Rule 501, Federal Rules of Evidence, provides that the federal common law of privilege applies unless the Constitution, a federal statute, or a federal rule provides otherwise. In a civil case, quote, state law governs privilege regarding a claim or defense for which state law supplies the rule of decision, such as a case arising under 28 U.S.C. 1332, Price versus Time, Inc., blah, blah, blah. So, however, federal law of privilege provides the rule of decision in a civil proceeding where the court's jurisdiction is premised upon a federal question, even if the information sought is relevant to the pendent state law claim. Here, the underlying complaint invokes both federal question and diversity jurisdiction, but as a journalist's privilege, the application of either the federal common law standard or Florida law will yield the same result. So deciding between the 11th Circuit and Florida standards is unnecessary. So it's all procedural. It doesn't matter which standard you're under, is what the judge is saying. State and federal, same result. The 11th Circuit recognizes a qualified privilege for journalists, allowing them to resist compelled disclosure of their professional news gathering efforts. This privilege shields reporters in both criminal and civil proceedings. And we're going to have journalists be a keyword here, as well as professional news gathering efforts. If you're just having a conversation about coffee and you happen upon some information, that's not necessarily professional news gathering efforts. If you're talking to your friend, you're not necessarily a journalist. You have to show how you are a journalist, engage in professional efforts. There's a reason, okay? I don't always agree with the court and how things happen. So just because I'm saying this is how it is and that there's a reason for it doesn't mean that I think it's complete, okay? I believe the protection should be much broader. But the reason that they're honing in on professional news gathering efforts is because professional standards, ethical standards in journalism, right? Like Gamergate or whatever. The ethical standards in journalism presumably vet the information to some level, to some professional standard that can be maybe measured and assessed. And if those professional news gathering efforts are applied, that provides a level of protection versus something that is more casual conversation. You have fact checking, you have source checking, you have these things that you do. You verify it with more than one source before you go to print. And in this case, before you have that protection, maybe you need to show that you applied those journalistic standards. Because if you don't apply the journalistic standards, then the information doesn't have the value of journalism. This is in the court's rationale. Not my personal opinion, but that's how it goes. All right. A party can overcome the privilege by demonstrating the information is relevant and unavailable elsewhere and that a compelling need supports disclosure. So even if you are privileged, they can still get it if it matters. We can skip a lot of this stuff. Standard applies even when the source of information is not confidential. So here's the Florida statute. A professional journalist, again, this professional thing, has a qualified privilege not to be, so not a right, but a qualified privilege under the right of the free press, not to be a witness concerning and not to disclose the information, including the identity of any source that the professional journalist has obtained while actively gathering news. This privilege applies only to information or eyewitness observations obtained within the normal scope of employment, does not apply to physical evidence, eyewitness observations, or visual or audio recording of crimes. So again, it has to be within the scope of your employment. You have to be investigating as a journalist. I think this is a bit not broad enough. I don't think it's broad enough because what is professional news gathering efforts, right? Like how do you define that? I think it's more expansive now than it used to be because of social media, because of how we communicate and network with people in different ways. It's changed. It's changed from 1940, 1950, 1970, 1990. It's way different now. So the section defines a professional journalist. And so this is a critical part of what Andy is talking about. Andy Signor is talking about how they said he's not a professional journalist because he's only on YouTube. Let's measure that out. Lacey Moreo says, I think you don't get I'm just Scottish. Say something in a Scottish or Irish accent and we are okay. I'm not. We're okay, Lacey. I'm not. I'll love you. I'll love you. Always have. There. I'll do my bad Mel Gibson impression of a Scottish person. All right. So professional journalism, again, as someone who regularly engages, quote, in collecting, photographing, recording, writing, editing, reporting, or publishing news for gain or livelihood. So you do it for the money. And to obtain the information, quote, while working as a salaried employee of or independent contractor for a newspaper, news journal, news agency, press association, wire service, radio or television station, network, or news magazine. I hate this. This is a journalistic license, and I don't think that's appropriate. Angry Gaming Dad says, rackets, why are they hard to train? Wait, why are who hard to train? What are we talking about? But I don't like this. I don't like the idea of a journalistic license. I think a free press means that citizen journalists are free press, and I don't think they should have to be attached to some organization. So here we go. Section 90.5015B specifically excludes from its coverage book authors and others who are not professional journalists. So you have to be a professional journalist to get a journalistic shield in Florida. All right. Although it applies to professional journalists only, the statutory language encompasses journalists working outside of traditional print media. This is where, see, and here we go. Outside of traditional print media. This goes against Andy's classification of it right away. So here we go. See Gubarev versus BuzzFeed, finding that an online-only news outlet and its reporters successfully invoked the privilege because the outlet qualified as a news agency, news journal, or news magazine that wrote and published news articles on its website. Similar to 11th Circuit precedent, it requires that a party seeking to overcome the privilege show clearly and specifically that the information is relevant and it cannot be obtained from alternative sources, and a compelling interest exists, blah, blah, blah. Here's the analysis, and this is what's the most important part. After we get into this just a little bit, we're going to wrap up. But this is the part where I take some umbrage with Andy's categorization of this. And again, I like him. I'm on his side. Sorry, I was just making a Jesse Lee Peterson joke from like an hour earlier. I'm a little off tonight. Look, Jesse Lee Peterson jokes are fine here.
Do you love black people?
What the fuck?
I just need you to be black and a female.
I just need you to be black and a female. So here we go. Popcorn Planet fails to show that the journalistic privilege applies and otherwise waives its claim of privilege. Signor formed Popcorn Planet on June 20th, 2022 as a Florida for-profit corporation for the purpose of media production. Signor's declaration claimed that Popcorn Planet is a 501c3 corporation, but its publicly available records with the Florida Department of State say otherwise. Judicial notice of these public records is appropriate. So that's a problem. Why does your declaration claim it's a 501c3? He reinstated the corporation on October 8th, 2025, after an administrative dissolution in 2024. Signor claims that he is an investigative reporter Again, that's from his declaration. And receives a salary from Popcorn Planet. He describes Popcorn Planet as a, quote, publicly accessible news and commentary channel. This is a first mistake. And himself as the show's main host. He should not have described it as a channel. He should have described it as a network. Popcorn Planet is more than its YouTube channel. Popcorn Planet, here you go, is a website, right? This fourth wall shop has a news feed, has exclusive content, has documentaries, has a merch store. It's more than just a YouTube channel. So don't call it a channel. Now, I haven't seen all the documents here. I'm taking the judge's word for it. The judge could be lying. I don't know. Judges lie all the time. Let's see. Popcorn Planet's channel is an account on the website youtube.com through which Signor publishes content. Signor describes the channel's content as news videos, some of which feature legal experts to comment on high-profile court cases involving celebrities. Signor claims that he is unquestionably entitled to invoke the section, as well as the common law federal privilege. Signor asserts that Florida courts have already determined that the statutory journalist privilege applies to internet-based entities. TX47, thank you for joining as a member over on Rumble. As long as they report the news. However, none of the cases cited by Signor determines as much or contains significant analysis of the statutory language. And here we got to go to these footnotes. These footnotes are devastating. Popcorn Planet is little more than a YouTube channel. But that's not true, right? Popcorn Planet has a Twitter presence. Like, a YouTube channel is just a place in which your business is able to engage its market. Like, YouTube is just a broadcast company. Like, YouTube has nothing to do with the production of Popcorn Planet, I don't believe. Or like, we'll just use like my Rekieta Law show, for example. YouTube doesn't make this happen. It's just a place I broadcast to. I broadcast to several places. YouTube, Locals, Rumble. I think it still gets mirrored on like BitChute or Odyssey or something like that. You know, like those things still occur. Sometimes on Twitch. It's not just a channel. But the judge is effectively saying that Popcorn Planet didn't describe itself as anything other. Although Popcorn Planet maintains a website that operates as an online shop for branded merchandise, Popcorn Planet has no independent website for hosting its video content. Why do you need that? Why do you need that? And you can say, and you're rightly saying, judge is a boomer. Yeah, of course. But you got to tell the judge. You got to define to the judge what it is. Popcorn Planet maintains an online account through the web service Patreon for fundraising, as well as accounts on other social media platforms. Look, Patreon, again, Patreon is not just for, fundraising. Patreon's not for fundraising, actually. Patreon is a place to post content for purchasers of the content. It effectively is a newspaper for your business. People pay for. You know, it can have show announcements. You can publish content directly to it. You can write articles. They have all sorts of tools available. We don't have an independent website to publish videos. Well, Patreon is a website where videos can be published, for example. I don't know about Popcorn Planet's Patreon. I have no idea. So here we go. As well as accounts on other social media platforms such as Facebook, Instagram, and X. Now, if you were a production company that produced news content and you published on several different cable networks right around the country, like you're on Spectrum, you're on Cox, you're on AT&T's Uverse or whatever, like you're on all these different things. That kind of sounds like a news network, like NBC does that, right? But here, the judge is dismissing that outright, which is wrong. But just because you have those things doesn't mean you adequately told the judge how it's a network. And again, I think Popcorn Planet is pretty clearly a network. Popcorn Planet's social media links directly to the YouTube channel as its homepage and for its content. Okay. Popcorn Planet's content including any paid exclusive content available through its Patreon or web store, is published and hosted exclusively through YouTube. So, again, where it's hosted doesn't make any sense to me. But if we go to footnote 4 here, Signor's motion contains the wrong citation for Gubarev versus BuzzFeed. In any event, Gubarev is neither controlling nor particularly persuasive on the matter of statutory construction. That's because this is a district court. It's not an appellate court. And as discussed above, Gubarev holds that section contains no language limiting the Florida reporter's privilege to traditional print media. It does not hold that the Florida privilege applies to all internet-based entities that report news. All right. So here we go. Similarly, Signor claims that he is a professional journalist as defined, but offers no analysis of the statutory language and concludes without explanation that Popcorn Planet satisfies the language. The judge is telling Andy, you did not tell me how you're any of these things. And that's going to be the theme here. Finally, Signor claims that the content published constitutes news because that content is information of public concern, namely the categories of entertainment, culture, and current events. The judge clearly takes umbrage with that. It's news when it is news. It's fact-based. It has a theme that is important to a public issue. Not just because you're talking about something publicly that is in the public interest doesn't make it newsworthy according to the judge. You have to tell the judge how. To qualify as a professional journalist, and I hate this. This is a part I disagree with from the judge heavily. There is no license for the free press. Signor must regularly engage in the collection and publication of news while working as a salaried employee or independent contractor for a newspaper, news journal, news at blah, 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 blah. Signor says nothing about how Popcorn Planet fits within the meaning of these terms. And this is where I think we're going to wind down and stop, because what the judge says overwhelmingly in this order, and I haven't reviewed, I haven't seen all the documents that they submitted about this. I don't know if they actually described it and the judge is just wrong, which is possible. Okay. I don't know. Again, I'm on Andy's side. I like him. I think he should have the protection. I think the Florida statute unfairly limits it, puts a license requirement on it. But that being said, this all boils down to, you did not tell me how you're a journalist and how Popcorn Planet is a news anything. That the words of the statute are right there. How is it a radio or television station? Well, NBC is a television station that is published on multiple third-party hosts. Again, Cox Communications, Spectrum, AT&T. I don't know whether any number of minor cable companies all host NBC. NBC creates the content, but NBC is a television station, and that station is then hosted by the content deliverers, the distribution network. YouTube is just a distribution network. So is Patreon. So is Twitter. So is Facebook. Their content is just distributed out to these things. They apparently didn't explain that very well. And that's the critical failure of what happened here. What it doesn't say is that something that is a YouTube channel cannot be a news network. It doesn't say that anywhere in this order. It just says that Popcorn Planet is nothing more than a YouTube channel. I disagree with that, but what I can't necessarily disagree with is that that's what the judge got from them, rather than getting a description of how it's a network published by these different channels or hosts or providers, in the same way that traditional things are. Just because yours happens over broadband internet rather than a coaxial cable network cable doesn't mean that it's not the same thing or of like kind. Thankfully, this is just at the district court level. But really, I'm getting tired of reading it right now because we've been going for a long time and I'm kind of exhausted. Why does your internet keep stopping and buffering? Is that your end? Yeah, that's your end. It's because you're in Europe. Will I be covering the Styx Hexenhammer legal drama? Yes, I think I shouldn't say yes for sure. Like I intend to. I reached out to Styx. I've never talked to him, but I would like to. And it could be interesting. But since he just got, he got his case dismissed 2 days ago, and then yesterday he ended up getting arrested after it was dismissed. And so there's a whole bunch of who knows what's going on. I don't know if he'll be able to talk about it too much. He's dead, Jim says, I agree, but devil's advocate, what about bad actors like Antifa, BLM, holding a camera, then claiming journalistic protection over their communications? Hear me out. Even if you have full journalistic credentials and have full journalistic shield, you still have to provide a log describing the communications, and you have to show how all of those communications are specifically related to news gathering. They're all challengeable, and the privilege can be overcome if they're relevant to the case, they're not available elsewhere, which private communications are only going to be available from two places, right? The source of the privileged communication and the recipient of the privileged communication. And there's a compelling interest to have those produced. You can overcome journalistic privilege. You can do it. You can pierce it. You just have to do that. The judge would go on to say that even if Andy did have journalistic protections, which the judge says he doesn't, that he's waived them, which is a separate matter, but also that even if he didn't waive them and he did have the protection, Blake Lively would still overcome it with her request. That's a big problem. That's a big problem for Andy in this case. I mean, I don't know that it's a big problem in this case, but it's a big problem legally for the legal posture that's presented here. I don't know if it's a grand problem or not. I have no idea. But it is not because it is merely a YouTube channel. And that is not an accurate communication. It's not an accurate assessment of what the order says. And it's frustrating to see that. And here's the real problem. Here's the real problem with reporting this incorrectly, right? You're saying that you're a professional journalist for a professional news organization. And yet when you report on the judge's order, you get it really wrong. That doesn't really lend credibility to the underlying claim. Not, it wouldn't have changed anything, but it kind of goes in. Yeah, this is why maybe you're not a professional journalist, is what the judge might be thinking. So, that being said, I need to probably talk more about the Popcorn Planet thing, but I've been really busy. Tonight has been wonderful. I've loved hanging out with you guys. I'm fucking exhausted, though. I am fucking exhausted. It is time for me to go to bed, get a couple winks of sleep. And then, I'll keep you guys posted on streams. Like I said, I'm going to be traveling in the very near future for a good chunk of December. And so when streaming occurs will occur when it can. Very conclusory, but it will. Follow on Locals for free, or you can watch on X for the announcements. You could try and rely on notifications on YouTube and Rumble, but those never fucking work. So follow on X, Locals, whatever. And that's the best way to keep track of what's going on. With that, guys, we're going to go ahead and play the outro. Play the full outro this time. And we'll see you next time. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes madder, raging at idiots from Twitter and Erland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a bow, more of Lothrog. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Blaming tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plentiful, from Dundee to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Blaming tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have.